Lordship, I beg to mention item number 4, Lordship. This appeal was preferred by the department. Lordship, in the meantime, there is a government policy. Lordship, I am seeking a instruction from the department, written instruction, whether the appeal will be maintainable or not, because there are some exceptions there. I've taken
This
consent
is
from
above 2 crore.
yes, Lordship. But here the value is about 1 crore 97 lakhs. But element of fraud is there. So Lordship, I am waiting for the written instruction from the department, whether they want to continue or withdraw in view of the latest. Lordship, maybe it listed after 4 weeks. Lordship.
Sorry.
No, because the commissioner is transferred. Lordship. New commissioner will join. Sir.
On the prayer for adjournment made by Mr. Speaker, submits that he needs to take some clarification from the appellate
Yes, Lordship.
in view of a new policy being implemented by the Central Excise and Service Tax Department. List the matter after 4 weeks.
Lots. Much.
Date.
Lots.
Right.
Okay, paper book has to be made.
Paper book with and lot
For the
I
IA,
Objection not yet filed.
yeah, had you have not filed?
no, not there was no.
As the PCR has arrived, registered to prepare the paper book. To stop Ms. A. Begum, additional PP shall also submit an objection to the IA in the meantime.
5 weeks.
It shall also, it also granted 5 weeks time to file written objection to the IA in the meantime. So we should, should we file it after in the, should we make 2 different orders? Make it 2 different orders. Yeah, make that part. List the matter after 5 weeks, both of them.
Deeply obliged.
Before my learned friend starts, this is the case, where they have filed in this appeal for cancellation of a pain, The copy has been served upon the accused in the jail, without the annexures, And the connected case is fixed on, 21st, And the matter will be tagged together,
In any case, Lordship, if he has not received the annexes, I will give him a question.
So you want to adjourn the matter?
Yes, to be listed along with criminal appeal number 285/25. Fixed on 21st of this month, 21/08/25.
Right. This the NJ data appears for the respondent and submit that the appeal copy that had been submitted by the NIA and that had been furnished by the NIA to the respondent was without annexures. Mr. R.K.D. Chaudhary, the learned deputy SDI, appears that he will furnish the annexures to the appeal within
Today, sir, no,
within the course of the
no, I have already.
okay, within the course. They submit that the matter may be listed on 21/8/22, 21/8/25 in view of the criminal appeal 285/25 being fixed on the set. List the matter on 21/8/25 along with criminal appeal 285/25.
I am obliged.
Meet to the Lordship.
Lordship with flag X, Lordship. The report is in the flag X of the ILM. Tomorrow will be distributed from last week to the order. It's order to GT order.
Where is the board?
Lordship, page number 4, Lordship. Page is not marked, but it is the 4th page, Lordship. There is no numbering.
Which one? This medical report?
Lordship, there is signature of all the board members.
Okay, okay.
On perusing that record Lordship, that report, the Lordship last date on 2025, learned Justice Lordship have passed the order that we furnish a report, copy of the order to session mental refer that
My lord will take up order dated 23/7/2025. This is after that report, this order.
Yes.
If your lordship takes up that order, it says so and so learned counsel draw the attention of the court to the order dated 16/6/2025 passed by this court, whereby a report was called from the Mental Health Review Board. Office note dated 21/7/25 has indicated that such report has not yet been received. So the report my learned friend is referring is prior to 16/6.
Maybe, but it was not produced, that's all.
Was that report has the signatures of all the review board members?
all the.
If that is the, then as per that, they will have to send this person
That's
to
the-
mental health care unit or whatever it be.
What does it say? What does it say? Is provisionally diagnosed as per ICD-10 as a case of paranoid
Schizophrenia.
schizophrenia in remission on medication. That's all. Doesn't have to, it's not required to send it to medical.
No, my lord. The provisions of the act says, if your lordship takes up this act, Mental Health Care Act, 2017.
The direction of the court to send this report to the order to chairman of Mental Health Review Board, Kamrup, Guwahati. Registry was directed to send this report, Lordship, and to
The lordship takes up section 2W, that is the definition of prisoner with mental illness. 2W. It states prisoner with mental illness means a person with mental illness who is an under trial or convicted of an offense and detained in jail or prison. Then your lordship will come to section 103.
Yes.
Now, 103 prisoners with mental illness. An order under section 30 of the Prisoners Act or under 144 Air Force Act or section 145 Army Act, this acts plus or section 335 of CRPC, directing the admission of a prisoner with mental illness into any suitable mental health establishment shall be sufficient authority for the admission of such person in such establishment to which such person may be lawfully transferred for care and treatment therein, provided that transfer of a prisoner with mental illness to a psychiatric ward in the medical wing of the prison shall be sufficient to meet the requirements under this section, provided further that where there is no provision of a psychiatric ward in the medical wing, the prisoner may be transferred to a mental health establishment with prior permission of the board. So, my lord, if he is a mentally ill person and if the jail does,
We do not know if he's a mentally ill person as on date.
schizophrenia is mental illness, my lord.
In remission, it says in remission. It says the word is in remission.
Then, my lord, if your lordship takes up 2S, what is mental illness? What all falls under mental illness? 2S.
Yes, yes.
2S. Mental illness means a substantial disorder of thinking, mood perception.
Understand, that part I understand. You see, when it says, there are persons with depression which is in remission. Now, can you call that person under depression when it's in remission? What is the word remission? You are forgetting, you are overlooking the word remission completely.
I understand, my lord.
Then, if it says remission, what does remission mean?
My lord, he is under medication.
Let us understand.
He is under medication. His issues have been subdued.
Correct.
Your lordship had passed a judgment in a matter called Upen Bosumatar. It was your lordship's judgment. There also he was a psychiatric person.
But that word remission was not there. I think.
No, that remission, he was a paranoid schizophrenic, it is there. My lord, in fact, in this court, in a case of Bangla Bhakti, it says schizophrenia can never be cured. It can never be cured.
No, so we have to see whether he will come under the definition of this, definition of S Yes.
Mental illness.
and W.
Means a substantial disorder of thinking.
This is substantial disorder. But whether a paranoid schizophrenia, which is in remission, can amount to substantial disorder.
And my,
That-
my,
In that case, if your lordship takes a mental, section, it does not just say substantial disorder, means a substantial disorder of thinking, mood perception, orientation, or memory that grossly impairs judgment, behavior, capacity to recognize reality, or ability to meet ordinary demands of life. Mental conditions associated with abuse of alcohol and drugs, but does not include mental retardation. So, my lord, if he's under remission, I understand he has been giving medication. Our contention is that a person who has mental illness cannot be kept in a jail. He has to be shifted to a psychiatric ward if it is inside the jail, the medical wing of the jail, or to a mental health institution. That is my prayer. These reports substantially prove that he is a prisoner with mental illness.
Yes, what have you got to say?
Lordship, this must be complied to the mental, chairman of mental health. They will decide, Lordship, whether he will need to be sent or not, Lordship. After going to the report, the board will decide, Lordship.
The board will decide.
That, Lordship, the chairman is there, Lordship.
Where?
It is in the
Order.
order of the 16, 6,
16,
2025, Lordship. Last para, Lordship. Already registry was directed, Lordship.
So he will decide. Okay, what is this application anyway? This 341?
My lord, this application, if your lordship takes up, we had come before your lordship because one order of this court was not complied with. If your lordship takes up paragraph 15 of my application, 1.5.
Just let me see what- Direction passed in 25/6/25.
My lord. Your lordship takes up
So
page
we will
15.
send this report to the, let it go to the,
Registry will,
let
Lordship.
him decide.
Lord,
Why I'm saying, my lord, just one page, page 15 specifically states, I had
15 of-
of my IA. Earlier, I had filed a suspension of sentence. This order was passed in that case. Your
it was
lordship
done
takes
in
up
that period of time, but Lordship, we have not, as it was disposed of.
paragraph 15, my lord. Paragraph 15 is the quote. It's a medical report that has been quoted. The mental health status report submitted by medical board constituted by principal cum superintendent Nagaon Medical College and Hospital on 8/6 has inter alia reported as under. Based on examination, information available and analysis of medical records, the medical board opines that the index patient, Sri Puniram Nath, is suffering from mental illness, namely paranoid schizophrenia, in partial remission. By nature, the mental illness renders the judgment of the person poor. This condition is manageable with medications, but the long-term prognosis is uncertain. Due to lack of historical information, the board is not able to comment upon the duration of his illness.
Then?
Subsequently, my lord, paragraph 17. It is further observed that on receipt of the case records from Mental Health Checkup Committee, the Jurisdictional Mental Health Review Board shall give due consideration to the case of the applicant on its own merits and in accordance with law. It is expected that the Jurisdictional Medical Review Board will give consideration of the case of the applicant and will pass appropriate directions. This was not done. It was supposed to be done within 15 days. This was not done. So we had come.
Where it is being done now?
So my lord, that report does not say anything. It only says he is mentally ill.
Correct.
What further? Can he be kept in the jail or has he been shifted to the mental health? That is my prayer, my lord.
So they will decide. Is there any whether in the jail also there might be a wing?
The Morigaon jail does not have a psychiatric wing.
Okay, but then whether he can be put in the jail, we'll see. Let them decide.
Let them-
Let the experts decide.
Now, the,
We can't allow him to be outside.
no, he cannot be outside. We are not saying that he can be outside. We are just saying he has to be shifted to a mental health institution.
So let the authorities, let the experts decide, not
Yes,
you
yes.
and, not you and me.
Exactly, my lord. So the a direction to this board that you decide where he can be
That
kept
is
as per section 103,
That is already there, Lord.
That's why we're going to say, we're going to send it to this chairman
my lord.
as per this order. Okay, right. Third, Mr. D.K. Bhattacharya, learned counsel for the applicant, and Ms. A. Begum, on an additional KP. This court, provide order dated 16/6/2025, and directed that as and when the Mental Health Review Board gave its consideration to the case of the applicant under the provisions of the Mental Health Care Act, 2017, the registry would transmit a copy of this order to the chairman, Mental Health Review Board, Kamrup M, Guwahati, for compliance with the direction made in the order dated 25/6/2024, passed in IA Criminal number 166 of 2024. When is that order passed? 166.
My lord, page 10 of my I. Starts at page 10. Relevant portion, page 15.
Page 15.
Relevant, 1 5, relevant portion.
Pursuant to the above order dated 16/6/2025, the Mental Health Review Board, Kamrup, comprising of Dr. Sri Parna Bhattacharya, Dr. Mithili Hazarika, Dr. Bornali Das, and Professor Dr. Suresh Chakravarti, have examined the applicant and the operative portion of the medical report issued by the 23/8/2024. 2024.
24 minutes.
24. States as follows. You take it down, okay? I'll just put this blue, blue. The registry is directed to send the said report dated 23/8/2024 to the chairman, Mental Health Review Board, Kamrup, Guwahati, to take a decision as to whether the applicant needs to be house. No. Whether the applicant is to be sent, whether the applicant can be kept in judicial custody or in a mental health
Lordship.
institution. In terms of the Mental Health Care Act 2007. A report should thereafter be, the report of the chairman should thereafter be produced before this court. This is the matter on when,
Lordship, they will take 4 weeks.
this is the matter after the, you were this.
September, develop time like you're gonna do, after. Lordship.
Wait, teacher Lordship. Lordship, you file this IA Lordship 430 application Lordship against the judgment and order dated.
They filed
Yes. They file objection.
Oh, you want to hear it?
Lordship, please.
Lordship, Lordship, I don't have any, because it is filed by my learned friend S.H. Bora, I hope, no? Lordship, Bora.
So,
So Lordship, let the paperwork be there, Lordship.
Yes. Yeah.
By S.H. Bora.
Lordship, it will be long if we do
I
paper.
know, it will take a long time.
Because today we have another hearing also, Lordship.
How does it matter?
That will take lot of time. Lordship.
That will take long, this won't take long.
Lordship, I don't have any.
Anything, you don't have anything.
Because the copy is with my learned friend as who have filed the objection, Lordship. Maybe,
It's your duty to get it.
Lordship, the office is to supply us, but they only 2 files. What? I'm helpless because I'm busy with this part third hearing.
Part third hearing, you're not even planning to make submissions.
Lordship, I have, Lordship. I have.
Oh, you're planning to get.
I have.
Lordship, in that case, a short date may be.
Yes, when do you want?
Lordship, this month itself.
Okay.
Any-
On the prayer for adjournment made by Miss A. Begum, learned TP. Which is objected to by the learned counsel for the applicant. Place the matter on.
Lordship.
Okay.
Deeply honored.
Wait, please, Your Lordship. Well, the evidence are in vernacular. If your Lordship is comfortable, maybe I can proceed.
Not at all.
My lords.
Lordship, because I think not me,
Miss B.
Lordship.
But same office.
Same office, Lordship, but once you take the responsibility that. It's a very matter. What? Lordship, short date, Lordship, next week, any date, Lordship.
If they don't have what to do.
Next week.
Same thing when the appellants don't come to the court. We can't dismiss it for default either. So we will have to accommodate if he doesn't have a copy. When do you want?
Yes, sir.
Give me a date. When you want.
Last chance, man.
Last one. See the next one, I said.
Yes, you know,
One, sir.
the very legal issue is important, my lord. That's before going to evidence, my lord, what happened in this case, my lord. These petitioners, my lord, appellants, initially, my lord, acquitted by the trial court. Then the against acquittal, my lord, the informant come for the appeal against acquittal. In the appeal against acquittal, my lord, there is a clear finding by the division bench that there is no evidence against these 2 persons, my lord. There is a clear finding that there is no evidence at all
not even for any room for any view to take, my lord. But considering that there is it has remanded back, my lord, that I'll not comment on it, my lord, but it was remanded back within finding that if you want to the prosecution, there's a liberty was given to the prosecution. If you want to adduce any further evidence, you can adduce it.
Any further?
Any further evidence, you can adduce it. And there will be a cross-examination by the defense, obviously. Then the prosecution says, we don't have any evidence. When it is returned back,
No.
prosecution say, we don't want to examine anyone, we don't have any evidence.
On the basis of those evidence only, I give that.
Now, this time, on the basis of that particular evidence, this time, the learned trial court convicted me. Same evidence, which was earlier acquitted, my lord, and the High Court has observed that there is no evidence against us at that stage. And on the basis of same material, he has reviewed not only his order, but also the order of the Honorable Division Bench. See the judicial propriety, my lord.
How many accused were there?
Two accused, my lord.
Two.
Two accused.
Two accused.
Both are acquitted.
Acquitted.
Both are acquitted.
Come to the High Court.
High Court,
Court has said that no evidence.
no evidence, my lord. High Court has opined that there is no evidence, but given a chance to the prosecution, if you want to examine any more witnesses, you can examine.
Where is that? Where is that order with the High Court?
My lordship, kindly take up my criminal appeal, my lord. 214, my lord.
What?
41.
Page 41, my lord.
The appeal or the appeal?
In the appeal, my lord.
Page
41, my lord. Yes, ma'am. Page 45 is the relevant last paragraph, my lord. Paragraph 12. Page 45. Last,
trial court is the same trial court. No.
but simple. Last 4 lines, my lord. We are of the view that in the instant case, the evidence on record is short of being adequate to arrive at any view as to what had happened, let alone framing two views, out of which one is in favor of the accused and one is favor of the prosecution. In view of the inadequacy of the evidence, we are of the view that the matter requires to be remanded back for taking further evidence as to make out the circumstances which resulted in the death of the deceased complete, madam. According to remand back the matter to the learned trial court for taking further evidence. In doing so, learned trial court shall give adequate opportunity to the accused so-and-so to render evidence in discharging their burden under the last seen together theory, and also to accuse Abdul Aziz to explain as how the dead body of the deceased was found in his house. In doing so, learned trial court shall also give an opportunity to both the parties to cross-examine any of the witnesses that have already been examined, and also to bring further witnesses for their examination in chief. As always, the cross-examination and the further purpose of the parties may bring the witnesses they would like to bring, provided otherwise admissible. Upon conclusion of the evidence, further opportunity to be given to the accused person to make their stance under 313 CRPC under the evidence.
Okay, where is the subsequent order?
Yes. Now, Lordship, kindly see the subsequent order, which starts from 48, my lord. The date of recording is the evidence is the same, my lord. It ended in 2013.
Where is the operative person?
Lordship, kindly say page 51. Paragraph 6 and 7, my lord. On receipt, this is the subsequent judgment, my lord. On receipt of the case record, gave opportunity to the sides to adduce their evidence on the basis of the judgment passed by the Honorable High Court. No further evidence was tendered by the either sides. In the learned public prosecutor has declined to produce further evidence and submitted before this court that the burden lies upon our accused to establish the defense.
Let us go to the operative person. Got it.
So that much, my lord. On the basis of now same,
No, some finding must have been made.
no, my lord, on the basis of the same evidence, my lord,
So,
recording evidence of the same, there is no recording of the further evidence, my lord.
no, forget the evidence. Some finding by the court, why it has to suddenly found him guilty, why?
Now decision, now the burden has shifted to the onus was to me, my lord, this time.
Why
Yes, my lord,
Only that.
only that. Whereas there is a clear finding. So on that,
Tuesday, Lord.
Tuesday, I will speak. Tuesday.
Tuesday, Lord.
It appears that,
Lordship.
point.
Tuesday, Lord.
Huh? This is the matter on 19th. On the prayer made by Miss Abela, This right one thing. The matter pertains to the apparent being fitted of the charge under section 302 by the learned trial. In the appeal filed by the informant before this court, it had been the finding of this court that there was no evidence to enable the court to come to a definite finding, either in favor of the accused persons or in favor of the prosecution. As such, this court had remanded the matter back to enable the prosecution to produce further evidence. On being remanded, the prosecution declined to produce further evidence. However, despite the evidence being the same, in the second round of trial, the trial court has convicted the appellant on the basis of the last together theory and the section 106 of the evidence. That's all?
that's,
List the matter. 190.
Can they supply a copy to me?
Yeah, nothing, it's so clear. I'll give you my copy on that, if you don't know. We share one copy.
Lordship.
No, it's quite clear. I mean, it looks like.
Lordship.
Congrats.
Keep your pledge.
Yeah, Mr.
A. Ahmed.
A. Ahmed. A. Ahmed. For
Appellant number 2 and 3.
2 and 3.
Here also I have prepared one small synopsis there. Your Lordship, may kindly see the background of the case. The date of occurrence is 14/10/2013. An incident occurred at about 6:30 p.m. And then your Lordship will find the name of the deceased is Pinaki De, and he died at about 7:15 to 7:30 p.m. And that is reflected in page 42 of paragraph first line, Lordship, last paragraph first line. Evidence of the informant. Then your Lordship will find police arrived at the place of occurrence at 7:30 p.m. Immediately police came, but no FIR was there. And this fact your Lordship will find from the evidence of PW 14 that I have written page 45 paper book 4th line of his cross. And it is reflected in the GD entry also. GD entry is there, that is exhibited as exhibit 11.
The yes, sir. Page GD entry 141.
Yes.
Just a minute.
Here my appellant's name is not there.
In fact, it was informed by that informant, informant himself. This information was given at
Okay,
8.
then,
So then your lordship will find the GD entry at 8 p.m. Then your lordship will find that seizure list was prepared, that blood stain of the deceased. That after that GD entry, I have mentioned that part. Blood stain of deceased was seized on 14/10/13 at 8:30 p.m. on the basis of the GD entry, which is exhibited as Exhibit 5, page 131 of paperwork. Your lordship may kindly see 131. Page 131. And date and time is there, third line, after that reference of GD entry, 14/10, 8:30 p.m. Now here, lordship, that witness number 1 of the seizure list, Piklude, his brother of the deceased, but no FIR was lodged. And other two witnesses, they were not examined. And now your lordship may kindly see that Scooty, where allegedly,
Piklude was examined,
yes, he was examined.
his PW,
Piklude was PW10.
and this Kanchan Das,
Other two were not examined. Kanchan Das and Nokul Das, page 132, they were not examined. And then Scooty was seized at 9:30 p.m. That after blood stain, your lordship will find that that was exhibited as at 125. Now this is important, lordship may kindly see page 125, exhibit 2.
yes,
Date and time of seizure, middle portion, your lordship will find that 11:10, 9:30 p.m. That is prior to lodging of the FIR. That witness number 1, that is probably also Shibu Saha. Father's name is same. I have compared it, lordship, but in the type copy it is written as something else. That Sileb Sahu is written.
who is
He-
Shilef Sahu?
Lordship, that
It should be
probably
Shibu.
PW4.
So there's PW4.
PW4. Father's name is same, that I have compared. And then next witness, your lordship will find page 126, Krishna Chandan, that is PW5.
Yes,
And down below, your lordship will find Papu there, that is the informant, PW13. So they came in contact with police prior to lodging of the FIR after the incident, but they did not lodge any FIR. And
there was an FIR,
no, the FIR was lodged at 11 p.m.
11.
11 p.m. And this seizure list were made. GD entry was there at 8 p.m.
Okay, prior to the FIR.
Yes, that is what I am trying to place into your lordship.
Papu Yadav is PW13.
Yes. Papu De. Papu De,
Papu Day.
De. PW13. Now, the FIR was lodged at page 1 of my the synopsis. Down below, your lordship will find that at 11 p.m. the FIR was lodged by PW13, and there is delay of 4-5 hours. Although alleged eyewitnesses came in contact with the police, lordship. Now, page 2, that only the prosecution issue which I have quoted there, that is only one line, lordship may note that in the GD entry, our name is not there. In FIR, they says the we surrounded the deceased. It is not that we hold the deceased or we hold the hands of the deceased. That is not the case in the FIR. So they are developing their case. That is what I am trying to project before your lordship. In the FIR, they said surrounded. That in the paperbook also, lordship will find page 5, middle portion. While the accused number 2, 3, and 4 surrounded my elder brother.
This informant is an eyewitness.
Informant came in contact with police as well as were in contact with other eyewitnesses.
Yeah. Yeah, it was contact was actually.
And then the rest are also that the facts of the case that police submitted charge sheet and witnesses. And here, Lordship, I have given the prosecution witnesses who are those shop owners and who are relative. Those I have given, Lordship, for ready reference. Now the contradictions part, Lordship, may kindly see at page 4 of my synopsis.
Yes.
PW3 Lordships, her statement that Purnima Sharma De, the accused persons that after I have given only the contradiction part, that allegation is there that we have hold the hand of the deceased. After that, Bipul hack, that part I have not mentioned here. So that is there, Lordship. The accused persons fled away when they saw me. I went to the place of occurrence.
Where does it say they saw me?
That
That's
yes.
that is PW.
PW3. Page 13, fifth line from top.
Where?
The accused persons
When-
fled away when they saw me.
When they
Saw me. I went to the place of occurrence immediately and saw Pinaki bleeding from the neck and chest. Later, I called my mother and with the help of one of the brothers of my father-in-law, it should be brother-in-law on that other day, your lordship said, took him to Lanka police station. So now in cross part, lordship, I am stressing that last paragraph of his cross, lordship. I was alone there. Second line of last. So she said she was alone. Now PW4 lordship says about 50 numbers of people gathered there after the occurrence. This statement is at page 18 of the paper book. I do not remember the name of other persons gathered there except Bapon Malagar, PW7. So he is saying about the persons who gathered there after the occurrence. Among them, that PW7, Asim Haldar, PW11, Krishna Chandra De, PW5. Now, PW5 says at page 20 in chief, I saw accused Osinta, Munna, and Krishna holding Pinaki's hand on their back and accused Bipul hacking at Pinaki's neck. And then I saw the accused persons running away. So that running away. When a hue and cry arose, the members of Pinaki's family came out. The shopkeepers who had shops nearby also came. So this is his evidence, Lordship. Now just the second thing I have given in within bracket, Lordship, that from the prosecution witness it appears the family members of Pinaki and shopkeepers who are examined as prosecution. PW5, Lordship.
Ah.
In bracket, Lordship, I have given who are the witnesses, that family members and shopkeepers. PW3 is a sister-in-law of deceased relative. PW4 is a nearby shop owner. PW8 is the mother of deceased. PW10 is the elder brother of deceased. PW11 is the nearby shop owner. PW13 is the younger brother of deceased. So these are the relatives and shop owners who came subsequently. Now PW7, Lordship, that Bapon Malakar, he in chief page 26 said, all on a sudden, accused Krishna De, Munna Datta, Bipul, and Asinto came and caught hold of Pinaki. Bipul De inflicted cut on the neck of Pinaki by means of weapon. Then we appeared there. Asim Haldar, PW11, Shibu Saha, PW4, Krishna Chandra, PW5, and Purnima De, PW3, also went there with me. PW3 during cross admitted that she was alone with which contradicts this witness. So I have already read out that portion where PW3 says she was alone. She was not with the PW7. And also this witness along with others subsequent. Moreover, this witness also contradicts with other witness on the aspect of all the four accused coming together. So this witness also contradicts regarding that. He says, let's say that 4 persons came together. But other witnesses say Bipul came subsequently from different direction. In first line which I have given,
They came separately.
separately. But
That
this
people was separate.
Bipul separate. But this witness said that all were together. In cross lordship, he again said that I cannot say whether Purnima De PW3 came before me or after me. One said that PW3 was with him. Then said he is not sure. Now PW9, Mono Chatterjee, in chief page 23, 32, said that then Pinaki fell down to the ground from the scooter after assault lordship. The accused persons had left. Later on, Krishna Chandra PW5, Bapan Malakar PW7, Dulal Devnath PW6, Asim Haldar PW11 and Purnima De PW3 came from their house. Now PW10 lordship in chief page 35, the accused persons immediately fled therefrom. Then said, my younger brother slowly fell down on the ground. He got smeared with blood. Right at that time, Asim Haldar PW11, Bapan Malakar PW7 and Dulal Devnath PW6 came out. Other people also came. So this came subsequently. Now what I'm trying to point out before your lordships is that I have given at page 6. First my point is that there is delay in lodging the Ajaha. I have relied on some citations I have given. So first that aspect lordship may kindly see that 2003 3 SCC paragraph 12 to 16 lordship. The mayor read lordship. Another doubtful factor is the delayed lodging of FIR. Paragraph 12. Page 355. The learned counsel for the appellants highlighted this factor. Here it is worthwhile to refer Tulia Kali versus State of Tamil Nadu, wherein the delayed filing of FIR and its consequences are discussed at Parasensor. First information report in a criminal case is an extremely vital and valuable piece of evidence for the purpose of corroborating the oral evidence adduced at the trial. The importance of the above report can hardly be overestimated from the standpoint of the accused. The object of insisting upon prompt lodging of the report to the police in respect of commission of an offense is to obtain early information regarding the circumstances in which the crime was committed, the names of the actual culprits, and the part played by them, as well as the names of eyewitnesses present at the scene of occurrence. Delay in lodging the first information report quite often results in embellishment, which is a creature of afterthought. On account of delay, the report not only gets bereft of the advantage of spontaneity, danger creeps in of the introduction of colored version, exaggerated account, or concocted story as a result of deliberation and consultation. It is therefore essential that the delay in lodging of the first information report should be satisfactorily explained. This is the position consistently followed by this court in Maharaj Singh versus State of UP and recently in Thanedar Singh versus State of Madhya Pradesh. As feared by the, so this part as a learned counsel for the appellant, the possibility of subsequent implication of the appellants as a result of afterthought, maybe due to political bitterness, cannot be ruled out. So here in this case, my case is also same lordship that I have pointed out. At the initial point of time, the alleged eyewitnesses as well as the informant came in contact with police, but they did not disclose our name. Even in the GD entry, which was lodged at the initial point of time, there also our name is not there, which was informed by the informant himself. And the next point, Lordship, that no proof that victim was given proper treatment at the initial point of time. That, Lordship, whether 302 will be applicable or not, because my case is that those witnesses were not there and he was not given proper treatment at the initial time. Because the evidence of PW 13, who is the brother of the deceased, he said victim died about 7:15 to 7:30. An incident occurred at 6:30. If that is correct, Lordship, then there is no question of giving immediate treatment. But if that is not correct, because postmortem is silent regarding when the victim died, that probable time of death, it is not there. And postmortem
Time of death is not there.
not there. And in fact, inquest was done on the next day at about around 11. It is only in the evidence of PW 13 that I have mentioned in my synopsis. It is there in page 42, last paragraph, first line. That he died about 7:15 to 7:30. And if that is correct, Lordship, that he died prior to arrival of police.
So if he dies prior to arrival of police, then
Police.
then what happens?
Then, Lordship, delay, they have to explain properly, because they said, Lordship, because of the treatment, the FIR got delayed. That part. And in this regard, Lordship, that whether 302, that paragraph 13 and 14, Lordship. That Arun Turi and others was a state of Assam. Two 2002, 2 GLP 198. In this case also, that initial report from the initial hospital was not produced before the court. Mr. So learned counsel for the appellants pleaded that if the medical evidence is properly appreciated, the testimony of PW 2, 3 and 5 cannot stand, and as such present conviction of the appellants cannot be sustained on the basis of the evidence of these witnesses. He also contended that prosecution totally failed to come up with an acceptable explanation as regards the whereabouts of the deceased from the period from so-and-so to so-and-so, especially when the deceased suffered injury on so-and-so, under Dergaon police station, and postmortem of his body was conducted on so-and-so at Gulaghat Civil Hospital, under Gulaghat police station. No reliable evidence was adduced to prove how and when the deceased in his injured condition was brought to Gulaghat Civil Hospital for his treatment and subsequent postmortem over his dead body. It was contended that even no medical report was called for by the prosecution to verify the factum of treatment of the deceased at Gulaghat Civil Hospital. And as such, there is an absolute failure on the part of the prosecution to remove the doubt as regards the involvement of appellants causing death to the deceased, and resultantly to prove the case against the appellants beyond reasonable doubt. We fully agree with the submissions advanced by Mr. Thakur and an in-depth scanning of the testimony of the witnesses. We unhesitantly hold that the prosecution failed to prove the offense of murder against the appellants beyond reasonable doubt, and the appellants are entitled to get the benefit of doubt in so far their conviction under section 302 IPC is concerned. My next submission before your lordship is that in the present case already I have pointed out, and my learned friend yesterday also pointed out the same thing. There are contradictions among the witnesses. Now my submission before your lordship is that the evidence, the witnesses who said the other witness was not present, their evidence cannot be brushed aside because the witnesses were not declared hostile by the prosecution. And a witness, prosecution witness who was not declared hostile, his evidence is binding on prosecution, lordship. That I am relying on 2005 5 SCC 272, lordship. that Rajaram, paragraph 9. But the testimony of PW8, Dr. Sukhdev Singh, who is another neighbor, cannot easily be surmounted by the prosecution. He has testified in very clear terms that he saw PW5 making the deceased believe that unless she puts the blame on the appellant and his parents, she would have to face the consequences like prosecution proceedings. It did not occur to the public prosecutor in the trial court to seek permission of the court to declare PW8 as a hostile witness for reasons only known to him. Now, as it is, the evidence of PW8 is binding on the prosecution. Absolutely no reason, much less as good reason, has been stated by the division bench of the High Court as to how PW8's testimony can be sidelined. So here also they are not declared hostile. So these were submissions on merit. Now, Lordship, my submission is on that section 34. Whether section 34 will apply in the present case. Because, Lordship, if for argument's sake, if we accept that the entire evidence is correct, then only the role attributed to my appellants is that they participated in the offense. Now, whether that is sufficient for conviction under section 34. Now, for that, Lordship, I am relying on AIR 1999 SC 1083. Because to convict me under section 34, more than that participation is required. That prime thing is that the common intention. And in the present case, common intention is absent because also PW 10 and 11 say when they were holding the deceased, they were not hurting the deceased. So in what manner they were holding? That is not there in the evidence. Now, paragraph 10, I am reading, Lordship, of AR 1999. That's Jai Bhagwan. Yes. To apply section 34 IPC, apart from the fact that there should be two or more accused, two factors must be established. One, common intention and the participation of the accused in the commission of an offense. If common intention is proved but no overt act is attributed to the individual accused, section 34 will be attracted as essentially it involves vicarious liability. But if participation of the accused in the crime is proved and common intention is absent, section 34 cannot be invoked. In every case, it is not possible to have direct evidence of common intention. It has to be inferred from the facts and circumstances of each case. Here, my case, prior to holding him, there was no quarrel. And the witness PW 10 and 11 says that they were not hurting. So how they are holding, in what manner, for commission of that offense or not for not commission, that is not clear from the circumstances. And where it is also not clear that whether they were holding him for slapping him or for stabbing him. That is also not there. And last, Lordship, that they were holding hands for that purpose, Lordship, that paragraph, the 2012 9 SCC 249. Here in this case, the accused was holding the legs of the deceased, while the other person stabbed him. So this is the fact. Paragraph 20, Lordship, I am reading. Paragraph, I am relying on 20 and 21. Even if we accept the evidence of, Lordship, yeah. Paragraph 20. Even if we accept the evidence of PW7, original accused 2, who turned approver, the role allotted to the present appellant was that of only holding the legs of the deceased as directed by A1. It should be noted that A1 was sitting on his abdomen and was holding his neck with one hand and also fisting his chest with other hand. And after fulfilling the work at the end, he directed the other two accused persons to catch hold of the legs of the deceased. Beyond this, there is no role assigned to the present appellant. Now, this section 34 is quoted that I am not reading, that your lordships are aware. So that two factors, and that part I'm reading, two factors must be established. First one, common intention and participation of the accused in the commission of an offense. It further makes clear that if common intention is proved but no overt act is attributed to the individual accused, section 34 will be attracted as essentially it involves vicarious liability. But if participation of the accused in the crime is proved and common intention is absent, section 34 cannot be invoked. In other words, it requires a pre-arranged plan and presupposes prior consent. Therefore, there must be prior meeting of minds. So that part is silent in the present case because PW 10 at page 35 says that Bipul came in a bike, subsequently in a bike, no, so he came alone. So there was no consent, and he came and directly assaulted. So that from the facts and circumstances, section 34 is not applicable to my opinion. That is my humble submission. Obliged. May I please, Your Lordship? Well, before going into the facts of the matter, firstly, like to point out the most important thing, the crux of the matter in this case, that the judgment is in challenge. The impugned judgment, we have to show what are the infirmities, what are the wrong, what is the other aspect that has been taken, perversity of the judgment, I'm not sure. So if your lordship will look into the judgment, my lord, let us turn for a moment, my lord. Though we are harping and arguing on 2 points, GD and dying declaration. What was the
DDN?
general diary and the dying declaration, my lord? There are 2 aspects in this matter, my lord, the oral dying declaration and the eyewitness account. So I started with the case by harping, my lord, that the GD entry should have been treated as the FIR of this case, my lord. But after going through the judgment, my lord, it transpired that the Honorable Trial Court, the respective trial court, has taken the GD as the FIR of this case. And the most important ruling fact, my lord, page, my lord, page 100, page 80, my lord. Para 1, my lord. An investigation of such a gruesome case was initiated on the strength of Lonka PS GD entry number 349 on the verbal information from one Pappu De regarding the occurrence. However, on the same day, the OC received a written Azahar FIR from the informant. Pappu De wherein stated that on 14/10/2013 about 6:30 p.m. when his brother Pinaki was sitting on the scooter in front of the rear gate in front of the Gopal Ashram, then the accused Bipul, Ashinta De, Krishna De, Pranavashish Datta suddenly came and attacked his brother with sharp weapon. So now as the case progressed, my lord, they started developing the theory of dying declaration oral. Then they came with the 34, my lord. Now what is the core case? Before that also I like to point out, my lord, that in this impugned judgment, my lord, the learned trial court, my lord, has not taken the dying declaration into account in any manner, neither for the prosecution, neither for the defense. So when it has not been taken into consideration for convicting the accused, my lord, so I think it will be a needless exercise to address that point, my lord. And likewise also regarding the GD entry to be treated as an FIR. So when the judge himself is dealing and we are challenging the judgment, my lord, so he has taken the GD entry as the proper FIR in this case, though the subsequent, the FIR which was filed will become only a subsequent statement and it will be clearly hit by 162 of the CRPC. Because anything after the FIR, my lord, in this case, the FIR is the GD entry. 2H. So in the judgment now, how I am convicted is the eyewitnesses account.
These 2 points goes.
Yes,
GD entry is.
yes, my lord.
Declares. So that was not relied on.
No, nothing, no discussion, nothing. And anything that is not taken into account, my lord, that means it's in the favor of the other side.
Additional statement, it became additional statement.
Became additional statement under 162, my lord. So if your lordship wants to have a deep look into it, one thing which I'd like to point out, my lord, is a definition of investigation has been defined under section 2H. Now, what is investigation? Before something may come, if the trial court has just done some wrong, my lord, your lordship has got ample power because appeal is a continuation of the trial itself. So your lordship can definitely look into it. But as I feel, my lord, that the investigation definition will be necessary in this case if your lordship is aware also, but still for full submission, my lord, I am submitting that it has been defined under 2H. What is investigation? Investigation includes all the proceeding under this case for the collection of evidence conducted by a police officer or by any person other than a magistrate who is authorized by a magistrate in this regard, my lord. So the investigation in this case has commenced prior to lodging of the FIR, and there are judgments from our Honorable High Court also, my lord, which I'll place it, my lord, when time comes. So ultimately, the judge has also relied the GD entry as the FIR of the case. And the dying declaration has not been taken into account while finding the guilt of the accused appellants. So now we are left with the only last limb of the prosecution case, that is the eyewitness account. Now, how much of truthfulness is there in the eyewitnesses account? What was the core case of?
You have given us that whole, that last time.
No, that was regarding dying declaration. Eyewitness account, I just started with PW3, then we winded it up. Because PW1 is the doctor. And even the postmortem, as I would like to submit, if your lordship would like to go directly there, my lord, I can add it. The postmortem report itself is not a conclusive one, my lord. If your lordship will see, the lordship. Okay. My lord, regarding medical things, I'd like to point out 2 things, my lord. It has been already submitted. I have also submitted on the first day. That when a person with such a injury was taken, homicidal injury was taken to the to the hospital, my lord, of Lonka PS first. Because they cross the police station, which is half a kilometer, and they goes to directly to Lonka PS, my lord. It was been prudent to inform the police and then to proceed, my lord. But they didn't do that. And they straightway went to the Lonka hospital. Now, it being, my lord, a medical legal case, my lord, it was the foremost duty, utmost duty of the honorable doctors, my lord, to inform the police that there is a medical legal case. That was not done on the part. Then it was a referral case. They said they were seeing the gravity of the injury, my lord. The Lonka doctors referred it to Ham Hospital because that was the big hospital out there, my lord, private hospital. So he was being taken. Now, if there was a referral, my lord, there will be some documents
which the police never visited, it has come on evidence, the police never visited any of the hospitals, save and except for the inquest and postmortem. The police didn't endeavor to go and to learn actually what was the happening that he was brought. That would have been made all things crystal clear, but nothing was stated. Because if the person was alive till 7:50, 7 to 7:50, he was alive, then my lord, the police could have easily gone, made arrangement, the doctor could have recorded the dying declaration, my lord. So these are the glitches and latches on the part of the prosecution, more particular.
Police was not intimated
Yes,
by the doctor.
by the, no, that is subsequent. While he was being carried to the hospital. Yes, no.
Is the hospital.
Hospital.
The hospital authorities would.
Absolutely, my lord. Since it was a medical legal case, it was the duty.
But from where you can see it was not done?
It's not on record, my lord. And lastly, my lord, definitely. IO's cross, my lord. Please do give a minute. IO's cross probably somewhere in 45%. In his cross, IO has deposed that he did not interrogate Horace Himangri, the immediate, and also the auto and the Lanka hospital, he did not go. Well, I'll read it from the evidence. If we come to page 46. Well, just where the signature Tonkesa appears, my lord. 46 in the middle, my lord, where the signature appears, your lordship will get the line. Shall I read, my lord? No weapon was recovered from the possession of any accused. I did not record the statement of the auto driver in which the victim was taken to the hospital. I also did not record the statement of any person of the Lanka Civil Hospital. I did not call for any record from the Lanka Civil Hospital regarding the treatment of the victim. So anybody going there, my lord, first aid would have been provided, at least some bandage would have been provided so that his bleeding is stopped. That's a normal conduct, my lord. And in a criminal case, your lordship will see what is the majority of the normal conduct of any person. And one line I would like to add, my lord, you will see at page 123 of the postmortem, my lord. Your lordships with vast experience will be aware, my lord.
Very little experience compared
No, your lordship.
to 23.
Yes, ma'am.
Yes.
My lord, page 123, I'd like to highlight from here, my lord, that the reason that these injuries were sufficient to cause the death of the person is not mentioned, and that is the requirement of section 300 IPC. That whether the injury was sufficient in the ordinary course to kill the person in order to qualify a case under section 300. 302 is the punishment and 300 is culpable homicide amounting to murder. I'm on, if your lordship will kindly look into my lord, section 300, my lord. This is chapter 16, my lord. Offense affecting the human body. 299 defines culpable homicide and 300 defines culpable homicide amounting to murder. Except in the case hereinafter expected, culpable homicide is murder if the act by which the death is caused is done with the intention of causing death. Or secondly, if it is done with the intention of causing such bodily injury as the offender knows to be likely to cause the death of the person to whom the harm is caused. or thirdly, I'm on thirdly, my lord, if it is done with the intention of causing bodily injury to any person and the bodily injury intended to be inflicted is sufficient in the ordinary course of the nature to cause death. Now, why I say and how I say, my lord, I'll cite an example, my lord. If a person gives a slap and he dies, was there any intention of mine to kill him? Was it under normal circumstance capable to cause the person's death? But sometimes it happens for many a reason that a person getting a slap dies. But that is not in the ordinary course of the death, my lord, that the person has died. So in this case, there is no opinion. Your lordship can take into the other paper book and have a look into it, that the doctor normally always says that these injuries were sufficient in the ordinary course to cause the death of the person. So this thing is clearly not reflected in the post-mortem manner. So again, coming back to my lord, the judgment part, my lord. I like, because we are assailing the judgment, my lord, is that it is bad in law, my lord. So I have to show that bad part. Now, if we go into the judgment, at page 80, I pointed it out that the GD entry in this case has been treated as the FIR. So we need not less to arrest. And after scanning the judgment, my lord, I'll verify it from my learned friends that whether there is any discussion of dying declaration. I did not find it. Kindly go through for like. Plea of LEB are, and very unfortunate, my lord, I have got a judgment also to that effect, that the judge, trial court judge has to first deal with the prosecution case. Here he has first started with the defense case, plea of alibi. It is the prosecution case who has to stand on his own leg, and on that plea of alibi is only an agent to supplement the defense case. So here we see that up to page 80 to 99, my lord, plea of alibi was being discussed. Then from 105, page 105, my lord, from 80 to 105, then the medical and all this fine. Now your lordship will see at page 105, my lord. In order to convict this accused appellants, my lord, the learned trial court below has relied upon certain PW. 1, 2, 3, 4, 5, 6, 7, 8, my lord. 8 PWs. Shall I point out, my lord, 105 page, my lord, first paragraph. Thus I find all the testimony of the prosecution witness, that is PW 13, 5, 6, 7, 8, 9, 10, and 11 are unshaken, which inspires confidence and trustworthy in absence of impeachment of their testimonies. So these are the witnesses which the trial court relied upon to convict this accused appellant. Now, how much they are truthful, whether their evidence inspires confidence to act upon by this honorable court now. How much genuineness was there, that I will be addressing to your lordship, my lord. These are the witnesses on whose account we have been convicted. And now, my lord, let us first start with PW3, because 1 is the medical doctor, 2 is the hostile witness, and 3 is the lady, the daughter-in-law of the house, who came to the.
But learned trial could not rely on.
No,
Please,
no, I've checked it. No,
in this paragraph here, this second.
no. In this paragraph only, he has found the guilt, that they are trustworthy witnesses, unshaken. Their evidence, we could not demolish it. That's why relying on those.
So does it show that PW3 evidence is totally left out?
That wrong also he has committed. But I will show, my lord, that PW3 was never an eyewitness. These are all planted witnesses. In this case, what I have found is strange thing, my lord. Everybody is trying to project that I have reached first and I have seen the occurrence by my own eye, which is a total lie. I'll try to show it, my lord. I'll try my best. Now, before starting with the evidence, my lord, we should first understand, my lord, what is the core case of the prosecution? What is the prosecution case? What is the charge against me? Because if there is any defect in the charge, I will not be able to defend myself. I must know what is the charge and what is the story of the prosecution case. Earlier, I pointed it out, my lord, that the place of occurrence is not mentioned. So I am highly prejudiced. And for that, I have a judgment of AI 2010 SC 3292. Para 9 and 12. দুটা কপি নাই কপি এটা দি দিলে আমার দিগদার সাইটেশনটো দিম নাই নাই মই পিছত ভালদৰে প্ৰিন্ট কৰি দিম ৰাইট নাও জাষ্ট অ্যাপ্রাইজিং দ্য কোর্ট হ্যাঁ বাবা আপনি দিয়ে না কি But I'm just reading today. I'm apprising the court, my lord. Actually, late night errors. Just giving a glimpse, my lord. What happens when there is something wrong in the charge, my lord? AIR 2010 SC 3292. Para, I'm relying on the para 9, 12, and 13, my lord. The following principle of section 212 to 15,464 of the code relevant to this case becomes evidence from the said inaction. The object of framing charge is to enable the accused to have a clear idea of what he is being tried for, an essential fact that he has to make. The charge must also contain the particulars of the date, time, place, and person against whom the offense was committed and are reasonably sufficient to give the accused notice of the matter for which he is charged. So in my case, my lord, jo date and time is given, but the place, because the place is also as per the evidence, someone is saying in the rear gate, somebody is saying in the front gate. So the prosecution itself is not sure, my lord, that where the occurrence took place, the place of occurrence. So the core case of the prosecution is that, my lord, that these three persons were catching hold of the deceased, my lord, and people they are submitting it. I came on a motorcycle. That is only one witnesses have said, and the other witnesses have said that I came walking a bit later and then I hacked him in the neck. What hack has been used, how it's written in assemblies, I don't know, but hack is one thing and slash is another thing. And then to give a blow is another thing.
With another thing.
My lord.
Stab.
Step. So the weapon here used was a short weapon, my lord. Can it cause such a big injury, my lord? 15 centimeter, running up to 15 centimeter, 12 centimeter in the neck, 15 centimeter in the chest. With such a small weapon, and that too, when a pointed weapon is used, my lord, then it will cause some puncture wound, like spear, like sizzle. All these will cause puncture wound, my lord.
See, the problem is that it depends upon how they use the English.
Absolutely. Correct.
Some people are proficient, some people are not. That is the problem.
No, that is there.
You have to give some concession there.
Because nothing has come, because the eyewitness could not say the manner of the weapon because of the fact that they have not seen the occurrence, according to me. I don't know them, my lord. But so far I am concerned, according to me, my lord, I was the person who gave the slash or hack, whatever it is, my lord. But if a person has seen it, then he could have been easily said that it was a knife. Last time I had come to know, my lord, that there was deliberation, that knife and all this thing. But nobody has stated the word used knife. I have made a list also. That if your lordship, I'll give it to your lordship, my lord. I have mine. All day.
See, your case that the weapon has not been specified.
Yes, specifically. So what Purnima says, the first eyewitness who comes to the immediately to the place of occurrence, according to her, that she did not notice as to what weapon the accused has brought with him. I have compiled a list, my lord. I'll give this, my lord. Then Shibu Sinha says it is a weapon was about 2-3 inch long. So if it is 2-3 inch, my lord, it will be only 4 fingers. That cannot cause this much of massive injury, my lord. And as your lordship is aware, my lord, when a sharp cutting weapon is used, then it will basically of incise wound. And when laceration has occurred in this case, my lord, there's this rough edges. So sharp weapon cannot cause laceration wound, my lord. In order,
This was taken yesterday.
yes, my lord. But a bit of modification I will say, my lord, that laceration is caused when something is rough in its edge. That I could get it from the medical dictionary, my lord. And sharp weapon give incise zone. It will have a slash. Like blade cuts, my lord. It will cut, my lord. And after some time only we will know that it has been cut, my lord. Will slowly. But once there is laceration, my lord, it will become a rumble strip type, my lord. So if it is a sharp cutting weapon, so there cannot be any laceration injury, my lord. That is my respectful submission. So I've compiled a list of the 7 persons who has seen the using of the weapon, but none could say what was that weapon named, be it knife, kukri, or whatsoever. So my respectful submission, my lord, that so we'll start from PW3, my lord, with the note that your lordship, the prosecution core case and the basic case is that the 3% were catching hold of the disease and A1 comes walking and he's slashed it. Only 1% has said that he has come in a scooter. So that means the coming itself is doubtful, my lord. So he cannot be an eyewitness because every other eyewitness is saying walking. So how can he say that accused has come in a motorcycle and gave the slash? So let us start with PW3, my lord. She is the wife of the informant, my lord, Purnima Sharma. I know the accused persons at about 6:30 p.m. My lord, knowing and identification are two different things, my lord. Anybody may know anybody, but when a person is in the trial in the dock, that identification will be necessary, my lord, because since none of the accused was caught red-handed at the place of occurrence. So here on the examination chief, it was the utmost duty of the prosecution to prove to these witnesses where these persons responsible for committing the offense. Then the witnesses would have applied, yes, the my sure.
I mean, you said that this judgment was written by a trial court.
Yeah.
This is on the GD entry.
Yeah.
But if you look into the charge sheet,
Yes.
the charge sheet says that the charge sheet was filed on the basis of the FIR.
Right, madam.
So
That's what
how it will be treated?
No, that's what I'm saying. I have
Because
got.
charge sheet is the main document. Right?
Yes,
So we-
absolutely. That is,
It's gone.
I'm obliged, my lord, because I would have been coming on that, my lord. Because the case was registered and the charge sheet was filed on the basis of the case. Case was registered, it is written. Yes, I have marked it, my lord. If your lordship will see the case number at the page 6. Receive and register Lonka PS case number 364 1410 under section 30234. So there is inherent defect in the prosecuting me, man. I've been not legally being prosecuted. So my respectful submission, my lord, I would have come, my lord. So investigation is done in a police case and charge sheet is filed in the GD. And the core case of the GD was different and the case projected in the FIR is different and the deposition given in the court is also different. So we have 3 versions. Nobody matching. Yeah. So I know the accused by at about 6:30 PM on 14th, the incident took place in the front of my gateway. So charge sheet says in the rear gate.
Look, Mr.
My lord.
Kumar, you had read this the last time.
Yes, no, my lord.
Read this, not only you, Mr.
Everybody has read that.
And
No, no, no.
also to have read.
I-
I mean, you have gone, we're going at the same thing over and over. The sketch
Yeah.
map you have taken us.
That is the issue, my lord, when we have so many
Remember,
applicants. Right.
The last day you had said, wait, I've got two more to mention, two more names to mention here. We had heard you very elaborately on the evidence. So there's no point, you see, this is the fourth time we'll be going.
Take,
Every
my,
time.
my lord will bear with me for a moment only,
Ah.
just to show that whether this PW can be termed as an eyewitness in view of the other witnesses' statement, that it was on
That is
the.
what Dev also said.
Ah.
Yesterday, he has taken us elaborately on that issue. That out here among the 50 people he could have.
I can skip if your lordship says, my lord, but.
Yes, because
I-
that's the same
Yeah,
thing.
sure.
Out here, we are going to say that he was alone, that she was alone. So, the same thing that was said yesterday.
Now, because two things, the eyewitnesses account from PW 13, sorry, 3, it transpires, my lord, that she is the first lady to come to the PO.
And that she was alone.
And she was alone. But the other witnesses say that on my shouting, the family members came running. So, PW. So, except Okim Haldor, as per the sketch map, none other was present at the place of occurrence. So, all these things are manufactured for the purpose of the case. And the core case that has been stated in the court, my lord, is that 3% was catching hold of the accused person. And accordingly, my lord, the my accused, that is accused appellant Bipul comes walking and he slashes it. And as a result of which he died. So the court came to the finding, my lord, since these 3 persons were holding the hands, my lord, so they facilitated it to happen. So your lordship has got it. I'll not point out, then page 21 is that particular line if your lordship wants to have a look.
Page 21.
Yes, my lord.
Yes, big portion. I was at a place 8
Mm.
to 10 meters away.
But when a hue and cry arose, the members of Pinaki came out. So the Pinaki's family member, who was 3 in number, my lord, I have compiled a list, my lord. Sir, what are you? Today, I'm just giving the list, my lord. Less factual aspect and the legal aspect, I'll compile and give, my lord. Who has examined on which point, my lord. So your lordship will see that there are 4 family members. Out of the 15 witnesses, 4 are the family members, my lord. PW 13 himself say he have not seen the occurrence, so he was introduced as to the dying declaration, my lord. So the 3 others, that is PW 3, 8 and 10, projected themselves to be the eyewitness. Again, I will show that eyewitness of PW 8 cannot be an eyewitness because she is a hearsay witness, and on hearing PW 3's version, she came out. That line I would like to show it, my lord. It will not make it. Page 29.
Yeah.
First page. When I was preparing tea, my daughter-in-law told me. Then the last line, I.
Yes.
Daughter-in-law, that is PW3, my lord. Then the last line, I immediately went to the place of occurrence.
59.
Yes, my lord.
PW8.
PW8.
Yes, I
I
immediately.
went to the PO in a run and saw the blood. So occurrence was over.
Correct.
But unfortunately, the judge has taken this PW8 into account, though he has left PW3's account. Likewise, PW6, my lord.
PW8 is not eyewitness.
Not eyewitness. Court is relying as an eyewitness witness account. I have given the chart, my lord, 5, 6, 7, 8, 9, 10, 11, and 13 has been relied upon to convict. Though 3 was left out, 6 has been taken, and PW 8 is not an eyewitness account. He was only the person who ferried the injured at that time to the Lanka hospital. So only carrying, nothing about occurrence, my lord. PW 8 has not seen the occurrence. He saw many people gathered in the rear side of the gate. Page 23. And therefrom he was referred to Hum while being taken to hospital. Pinaki said, so I said that to which hospital is nothing stated there, my lord. So this 8 also should not have been taken into account while finding the guilt of the accused. Now, likewise, my lord, that these other witnesses are all official witnesses regarding the inquest, regarding the PM, and regarding the FSL. So if we look into the accounts, my lord, that there is total variation. We get 3 stories. One in the FIR, one in the GD, and one in the court. So now which is to be relied? So if we looked into PW7's evidence, my lord, if Bapan Malakar, who is said to be the eyewitness of the case, my lord, claims to be an eyewitness of the case, he saw Vipul De cut the neck of Pinaki by means of a weapon. So no chest. If a person has seen the whole thing, first it was in the neck, then chest. But this eyewitness doesn't see the second injury. Why?
Okay, then.
Yes, man. He doesn't say that Vipul had caught hold of Pinaki along with the other co-accused, my lord. And he says, my lord, most important thing, an eyewitness account. Second line from the down, my lord. All on a sudden, accused Krishna De, Munna Datta, Bipul, that is my accused, and Osinto came and caught hold of Pinaki. Now 4% catching hold. Earlier, the core case is that 3% catching hold, which facilitated the accused appellant, my accused appellant, to give the slash. Here, now it comes, this eyewitnesses account comes as that 4% came and caught hold of Pinaki. And Bipul inflicted cut on the neck. That means all the 4 came together.
No, but then this Achinta and Munna are the same person.
And all are present. I'm showing one by one, my lord, that these are not trustworthy witnesses. These are planted witnesses, planted eyewitnesses. They are made eyewitnesses. Chance witnesses. Except Okim Haldar PW 11, my lord, nobody's name surfaced in the sketch map that he was present at that place and time, my lord. So if there is any, I submit, my lord, then the real eyewitness will be one of it is that PW 11 at the base. Rest are all coming after the occurrence, taking the injured to the hospital. So there cannot be an eyewitness account. And above that, it was a dark night. Of course, not pitch dark, but it was somewhat dark, madam. There was no street light shown in the sketch map. There was no puja mandap shown in the sketch map. In fact, the puja mandap was a bit far off, about 20 meters or something like that, madam. So my respectful submission will be, my lord, for not for repeating sakes, my lord, that if we see PW 11 evidence, my lord, it's page 37.
Yes.
Because PW's 11 name surfaces in the sketch map, wherein it is said that he was sitting in his shop and he has observed it. Now, I'll read that evidence because
Yes.
Mal. This witnesses is the key witness. If your lordship will look into the whole case, the case record, my lord, that as per the sketch map, he was present at the place of occurrence, and that has been already denoted, and I have pointed it out. So will not happen upon that much, except the fact that index B shows that Okim Haldar had the stationery shop at about 15 meters away from the PO. He has witnessed the incident. That is the IO's index, my lord. Now, what is the evidence? I know the complainant Papu De new victim. I also know the accused person. I was sitting in my shop at about 6 to 6:30 p.m. on 14th, the day of Doshami of Durga Puja. Pinaki De was sitting on the scooter on the other side of the road in front of me. It was not in front, but it was 50 meter away, my lord. 15 meter away, about 30 feet away. At that time, Osinto, Munna, and Krishna caught hold of the hands of Pinaki, were pulling him backward. None of the witnesses have said that the accused was pulling him backward. Only caught hold. Immediately, Bipul came and caused the injury from chest to belly. Now, if he is an eyewitness, what about the neck injury, my lord? He has not seen any neck injury.
No, then it comes out next page.
My Acha. Bipul came and caused injury on the portion from chest to belly of Pinaki by means of Sazar. The accused immediately fled the place of occurrence.
Blood was coming.
Blood was coming out from the neck and belly. No, he did not saw. Blood may come because of many other things. What he is deposition, my lord. Blood was coming out, but he has seen causing injury by Bipul from chest to belly. No neck. Neck injury not stated. Other witnesses say came first slash the neck, then second the chest. And that is corroborated by medical. But this eyewitness must see the truthful account, what he has visualized it, what he has seen it on the day itself. So why will the eyewitness not see the accused giving a cut in the neck? My friend can kindly verify it, whether if there is any typographical, I don't know. But whatever it is given in the paper book, it looks like that there was no neck injury he has seen.
It's all right. It
Huh?
is all right. Maybe he have seen because the accused will not say, lordship, come view that I will cut him or I'll assault him. So after getting the neck,
No,
then
these are
he
all in
will see
Hindi
the-
picture. You come and I will cut you.
assault.
What is in evidence you read?
If he have said that he have seen while he was in
Where?
he-
Show.
he was
He
while
has
I was
seen only
sitting, I have seen the cut
Hmm.
of my chest to belly.
Okay, anyway, next. Continue.
I am submitting
will-
that
that
he
he
has
has
not
seen-
seen the neck injury
Like
cut.
after.
No, you can, you will give me your.
Not even. Only.
So if your lordship he is speaking the truth, then he should have seen the injury given in the neck. Like other witnesses have stated, those who were non eyewitnesses, they have given the version as if it was neck. So whom to now trust and believe, my lord? And after causing the belly injury, cut injury, the accused person fled away from the place of occurrence, but he saw blood coming out from the neck of the PW. Then we all together put Pinaki in an auto and took him to the hospital. That is there, my lord. And other glaring defects, my lord, I like to point out, my lord, regarding 164 years. Let us come to page 127. This, all the 164 en bloc was recorded on one day, that is 5 days of the occurrence. I have stated earlier, my lord, that there were many a time,
Defense witnesses.
yes, 5 days for manipulation.
5 days?
5 days is the gap of recording the 164 statement. It should have been done at the earliest possible manner. In a murder case, my lord, there should not be any space for manipulation, any space for an afterthought. My learned friend has earlier submitted delay in the FIR. I said that there may be injury and all this thing, but the police ought to have got the witness statement recorded at least, the independent. Now, if your lordship will come to Dulal Devnath's statement, who is PW6, who claims to be an eyewitness of the case.
Page?
Page 127.
Yeah.
This is another story. My lord, I think your lordship will have a look in the original. Brother lordship can have a look in the original because some glaring mistakes are there, man. Exhibit 3. When will come, my lord, certain glaring translation is wrong. Way. Exhibit 3, my lord. The 164 statement of PW6, who was recorded as witness number 2. Exhibit 3.
Dulal Devnath is PW number 2.
6, my lord. It has 164. There are 4 164, my lord. I have given the chart, my lord. Or the other. No, my lord. Ma'am, apart from the chart somehow got left, my lord. I'm giving. Ata দুটা pay possible. Itu ma'am দুটা photo state না হবে নাকি? দিয়ক না? Mail, page 8. We'll take the trouble if you like to. Got it, madam? Yes. Witness number 2, Dulal Devnath. And in the court, he is PW6, madam. And his statement was recorded after 5 days of recording the 161 statement. It should have been gone together. I'm not sure of the date. That is for the prosecution. PP may kindly verify and say when his 161 was recorded. But it was 5 days after the occurrence because this was recorded 19. Oh, 94. Occurrence is on 14. So I read, my lord. Your lordship will see. I saw the victim Pinaki Day lying on the road near his house and he was bleeding. So if it is looked into his 161, my lord, it's English. But there is no signature out here. Normally they made photocopies. So it will be very interesting then, my lord. Sure. Because normally signatures are taken. Since there is no signature, I thought it is a type copy, my lord. Normally, suppose in the deposition which is made photocopy, signature of the witnesses come in. Then it will be very interesting. I was taking care that no mistakes happen. So this says, I saw victim Pinaki lying on the road near his house and he was bleeding. So this PW6 cannot be an eyewitness. Yes. But his account was taken. I picked him up in an auto and took him to the hospital at Lanka along with Topos Devnath, who is not examined. And 2 other persons, I do not know. 2 other persons, no name stated. But 2 other persons cannot be because in the auto 3 persons went. That is Topos, he himself, Dulal Devnath, and 1 Piklu, PW10. Again, there is a glaring mistakes, my lord. Then he meets Pappu Day, that is PW 13, at Syndicate Lanka and went to Lanka PS in the auto. That is something troubling. That's why I said your lordship may kindly verify it. So they goes to Lanka PS.
This 127 is 164 statement or what?
Yes, one second. That's why I asked your brother lordship, your lordship, to check whether it is translated. Your lordship can have a peep onto the original. I was thinking all the time, Malum, that I was wrongly translated. That's why I was submitting, my lord. It was on the way, half a kilometer. Then comes my lord. The doctor referred the victim to Ham Hospital and we took
Just a
him to
minute.
Ham Hospital. So they, as per this version, he cannot be eyewitness, but of course he comes to the place when the occurrence was over. Because Pinaki was by that time lying near on the road near his house.
What happens when there is a contradiction between his testimony in the court and in the 164 statement?
Because that will throw, because 164 can be used for two purposes, your lordship, either for contradiction and for corroboration. 161 is only for contradiction. So here we can use in both the way. So if from here we show what is the first version on oath. So he is a lying witness. The whole prosecution story is punctured because if he was taken on statement on oath, my lord, relevance, he was not 161. He was taken to the Lanka PS in the auto. So if it is in the Lanka PS, my lord, why the police station is not saying anything regarding that, my lord? And as I have submitted at the outset, it was only half a kilometer from the PO. Nowadays in electronic world, my lord, anybody can ring 100, anybody can ring anywhere and give the information. So much of people were there. Natural reaction will be that, my lord. But police comes to know at 7, he comes out. I don't know how, because the GD itself was on 8 p.m. How in advance the police came and did the investigation, that is also a mystery, man. 6:30 occurrence, 7:15 date, 8 p.m. GD, 11 p.m. FIR. But police comes to the PO at 7:30. Well, just I'm finishing this one, my lord. The doctor referred the way along the way. Now another big thing will come, my lord. Your lordship may verify it. Along the way,
Which para?
my lord, the last para.
Which page?
My lord, 127. I'll complete this one. So 4 lines. Along the way, Pinaki told Bipul Day and had attacked him, and on being asked by Papu, he said Osinto Krishna Munna has caused the injury to him. So how can this 4% now cause the injury? The core case is that 3% tying up the hands and the 4% causes the injury. Here all 4 now is causing the injury. So the dying declaration is apparently wrong. That's why the court did not rely upon it. And now another improvisation that all the 4% has caused the injury.
Then
So then I finished for so far is that because false, he was caught whole and no corroboration on this part. No confirmation on this part. This 164, another thing, as your lordship has asked, that's why I'm submitting, my lord, that 164 itself by itself is not a substantive piece of evidence. It is the court evidence that is substantive. Now I am showing that there is no corroboration, rather there is contradiction. So this witness become a false witness, an untruthful and untrustworthy witness, which cannot be relied upon to find the guilt of the accused, but he has relied upon the trial court. Well, they have come, my lord. Shall we continue? At 2 o'clock. At 2 o'clock. Can I start, my lord? My lord, I was taking, prior to lunch, my lord, I was taking your lordship to the 160 floors of 3 PWs, my lord. There are 4 PWs regarding whose 164 was recorded. I have already taken your lordship to Dulal Depna PW6 at page 127. Now I'd like to go to the second 164 of Bapan Malakar, who was examined as PW7 in the court at page 129, my lord, exhibit 4. Bapan Malakar, who also claimed to happen to be an eyewitness, which he is not, your lordship will see, that it was statement was recorded after 5 days, again on the same day on the 19th. On 14/10/2013, on the day of Dokomi at about 6 to 6:15 p.m., the victim Pinaki was sitting on a scooty near the back gate of their house on the main road. At that time, now the occurrence, my lord. At that time, Osinto, Munna, Krishna came and hold Pinaki. So he doesn't state the manner how it was hold, only hold Pinaki. By hands or back, nothing has been stated. Bipul Day came. So he came also is not there because one witness said in a scooter, others said by legs. So that is also not specified. And Pinaki told Pinaki why he assaulted his brother. But in the evidence, nothing has been stated regarding this fact. That there was a saying that why he has assaulted his brother. And saying that he assaulted Pinaki with a sharp weapon on his neck, throat, and stomach. So again, stomach has come. Stomach is the lower portion of the chest, my lord. So their version about witnessing the occurrence, my lord, becomes highly doubtful, my lord, and becomes unreliable. Then we come to the next one. Okim Holder, my lord, PW11. On 14/10/13 at about page, 133, my lord. এই দুটা delivery please.
PW11.
I have given the list, my lord. Yes, PW11. On 14/10/2013, around 6:30, I was at my shop. There was a scooty parked in front of me on which Pinaki was sitting. Suddenly, I saw the Osinto De, Krishna, Bipul, and Munna Dotto had come. And Bipul De assaulted Pinaki with sharp weapon and he fell down. Bipul De shouted why Pinaki had beaten his brother and assaulted. People gathered and took him to hospital. I saw the incident from distance of 10 to 15 feet. In the deposition is 15 meters, my lord. And as the index also said that he is situated at 15 meters, not 15 feet. Because meter and feet become great difference, my lord. 15 meters is equal to 45 feet, my lord. Here I will just pause and submit, my lord, that his full version is that suddenly I saw Osinto, Krishna, Bipul, and Munna Dotto had come and Bipul De assaulted Pinaki. No catching of hell, no holding back, nothing is there, my lord. Then the last one, my lord, is at page 138. He is the informant PW13. Papu De, the brother PW13, who is not an eyewitness to the occurrence regarding the oral dying declaration he has deposed. On 14/10/6/15, I was at Lonka bus stand. I was informed by my friend Kosik Chandra that my brother had been murdered by Bipul Dey. So again, I will pause it for a moment and submit my lord. This Kosik Chandra has not been examined before the court, neither by the IO. And one of the witnesses, PW, 11. PW 11 has said that he has rang up. PW 11, please. Because PW 11 says that my lord, while he was here, then phone came from my lord to the PW 13 that their brother was killed, my lord. My lord, I am just reading vis-a-vis page 41, my lord. Pinaki is this person, Papu Dey. Papu Dey is PW 13, my lord. He is the brother of the deceased Pinaki, who states about the first-hand information who wrote the Azahar as well as the GD entry on whose information it was recorded, my lord. So vis-a-vis, what is his deposition? His deposition is that third line. I was at Lonka bus stand at that time. It is corroborating. Then I received a phone call from my house and I was informed that accused Bipul, Osinto Krishna, Moravashis and Munna had cut my elder brother. Munna. That is all four has given the cut. Page 41, my lord. That is his deposition before the court. On the other hand, in his 161, he says that he was informed by Kaushik Chandra, not from the family members. And Kaushik Chandra has not been brought before the court to test his veracity, whether he is actually informed or not. I immediately rushed to Lonka hospital. So he goes directly to Lonka hospital, whereas he said that he boarded the auto. If you again go to page 138.
This Kaushik Chandra and this other,
No, my lord, he is not a witness.
this Krishna Chandra is different.
It name was, if it is original, my lord, so it is Kaushik, my lord. Your lordship can verify.
PW5 is
Yes,
Krishna. So is this Kaushik and Krishna same or is it different?
it has not come, my lord. We'll look it. He is a chance witness rather.
Okay. Next.
But just check it if your lordship, there is a query. In his deposition, he doesn't say that he informed PW 13, my lord. From his deposition, it does not transpire, my lord, that he has informed this PW 13, my lord. So he cannot be the same, my lord. He is not Chandra, actually, he is Krishna Chanda, PW5. Not Chandra. He is the person who is referring PW 13 is Kaushik Chandra. So from his 161, we get that he was informed by Kaushik Chandra, but in his deposition, he says that he first received the phone call from the family members. And he immediately rushed to Lonka hospital. So his boarding the auto becomes doubtful. With my brother, along with Debashis, Topos Devnath not examined, Dulal Devnath 6, Piklude 11 in an auto. The doctor of Lonka hospital advised me to take him to Ham hospital at Hujai for treatment. So there was an advice, but that advice note and nothing has been placed on record. I took my brother to Ham hospital in an ambulance along with Topos Devnath, Piklude and Dulal Devnath. I asked my brother about the incident on the way to the hospital. That is which hospital he has not specified, whether to Lonka hospital or to Ham hospital. My brother told me that Krishna Oshinto assaulted him and came and sat in a scooty in front of our gate of our house at Netaji. After about 5 minutes, the accused Krishna De Osinto and Prasanto Munna came and held my brother. Pinaki Day and Bipul came and abused my brother and inflicted cut wounds on his throat and below the chest with a sharp weapon. So this is again a new story which is sought to be introduced, my lord. My brother was bleeding profusely and died before we reached the hospital. We had initially thought he has become unconscious, but the doctor declared him dead at the hospital. I could not write down what my brother said as we were not in a position to do so. And as I have submitted, my lord, in the judgment, no consideration of dying declaration. So 164 is on a different note, my lord, from the court case. So, my lord, with all respect, I'll submit that if we go through the evidence on record, my lord, that is the substantive piece of evidence, my lord, it is not matching with any of the witness, my lord. And as I have already submitted, my lord, other witnesses, save and accept that Okim holder, PW 11, no one was present at the place of order. All has been planted as an eyewitness in this case to build up a false case against the accused person. And there were variation in other cases. So, my lord, with this, I conclude it. And furthermore, by adding one or two lines, my lord, 313, he has totally denied that we are not involved. Rather, a plea was taken as to plea of alibi, my lord. And I think it was rightly rejected also. But the set was there. He is that we have not committed the crime and we are not present at the place of occurrence, though our plea was not accepted by the trial court for some good reasons or some other reason. It was not taken into consideration. So that being the position, my lord, the stand of the prosecution, the defense was throughout that we are not involved in the case. Due to some enmity or something like that, we have been implicated in the case. So that being the position, my lord, this eyewitnesses' presence is doubtful. Their version is consistent, not to be relied upon for finding the guilt of the accused. My lord, if your lordship permits me, my lord, regarding the judicial pronouncement and the bullet points, if your lordship will give me till Monday, my lord, I will prepare it, my lord. I have got everything, but only I have to compile it. Today, I will not be in a position to give, but I have given those lists, my lord. Various lists I have given it. Your lordship in the meantime can have a look, my lord.
You can give the bullet point, but we won't, but we can give it to this, separately. Because my brother will be sitting somewhere.
Gotcha.
So we won't disturb, you know. Unless he doesn't complete the side of the. You're going to complete today or?
Basically, we have completed it. Only my legal thing, I could not synchronize it.
Give me the bullet points and his citation.
No, my all things are prepared. Only I have to scrutinize certain things, my lord. I prepared around about 10 to 50 pages. Today is not possible because I came last night lately.
Yes.
May I?
No,
Or-
first they are going to ask the permission.
Yes, it's been granted, minor. With the leave of.
I thought we had already heard most of.
Yes, only in the reply side. Now, with regard to the point they have raised while arguing this matter. Now, the first point that has been raised is with regard to a GD entry and thereafter lodging of the affair. And it's been stated and submitted before this honorable court that the FIR is being hit by section 162 of the CRPC. That's true, man. That becomes inadmissible as per judgment. But the whole case is with regard to a information that has been received at a situation wherein a murder took place or a attempt to murder took place at that relevant point of time. And it's been a message over phone. And it's been noted, and as such, the investigation proceeded. And the documents, the seizure and everything corroborates the everything. So far, with regard to that particular ZD entry is concerned, the investigation started. And during investigation on the date of occurrence, all these witnesses has been examined. On that particular day itself, when, my lord, this occurrence took place. And
8 p.m. the FIR has been lost and
FIR lodged in 11.
11, my lord, occurrence took place with regard to this. Now, on that GD entry itself basis, my lord, this witness is examined. They are sticking,
So the GD entry is the FIR.
is the FIR, maybe FIR, my.
No, so what is the FIR there? What does the FIR?
FIR is hit by 162, so it become inadmissible as per Evidence Act because it is signed. So 161 statement is not, if it is signed, then it hits this. My lord, the Evidence Act, section this, my lord. It becomes inadmissible in view of, my lord, it's been signed by the, my lord, particular person in the FIR. The informant signs the FIR. So it becomes inadmissible evidence. But the investigation started on the GD entry. On the basis of GD entry, my lord, the statement of witnesses are also been examined. Now, the 164 statement also been recorded. That is corroborative value, no doubt about it. But once it is come to the court of law, my lord, wherein, my lord, it's been subjected and exhibited in the court of law, the defense has the right to cross-examine and put all such questions which has been paramount. Whether the cross-examine says so, my lord, it's been a defense taken for the first time in the appellate court, my lord, and it's not reflected in the cross-examination itself.
What aspect?
With regard to, my lord, that my lord, that the GD entry, and with regard to the previous statement that has been made during investigation by witnesses. Now, so far contradictions are concerned, there is no as such contradiction which goes to the root of the case and to disbelieve the prosecution case. What is their plea? Plea of alibi. I'll come to that later on. Now, at the point of charge, they have raised a point.
They're not going to alibi. They're not even going there.
They were not there. So that is section 11 of the.
They're not taking the fee. They're not taking the money. They're not taking the fee of they're not even going into the dying declaration.
That's a different issue. I'll come to that, my lord. So far, plea of alibi, my lord, it appears, my lord, from the 313 statement, from the suggestion given during cross-examination. So and so is not there. So that has been a burden under section 105 of the Indian Evidence Act by way of defense witness. We'll come to defense witness. It has been demolished, my lord. So far, with regard to the charge, the next question is on the charge. Now, what is charge? Charge is chapters, section 210, it's 211, it starts with, my lord. And it's a notice to the accused person with regard to the allegation level against him. Yes, in the charge, it is not there. The place of occurrence is not there. Now, for that purpose, whether whole of the prosecution case goes, absolutely no. Because during cross-examination also, there is not even suggestion. They are saying they are prejudice. Now, if they are prejudice, that ought to have come during cross-examination. Infinite number of occasions been given, but they have not cited with regard to this. Apart from that, my lord, 464 of the CRPC, my lord, makes it clear, my lord. What is 464, my lord? Effect of omission to frame or absence or error in charge. No finding, sentence, or order by a court of competent jurisdiction shall be deemed to invalid merely on the ground that no charge was framed, or on the ground of any error, omission, or irregularity in the charge, including any misjoinder of charge, unless in the opinion of the Court of Appeal, confirmation or revision, a failure of justice has in fact occurred thereby. So if there had been a failure of justice and in the cross-examination, it would have been reflected, that would have been a different. 464.
This is equivalent to?
CRPC, new law, my lord. I will.
We can
Yes.
keep on harping on the back.
Yes, my lord, I'll give it, my lord. It's difficult, my lord. 464, notun law to find. Now, charge has been explained with regard to this. Now comes to the evidence part, my lord. They have been saying they are not an eyewitness, they have been cooked up case.
Not present.
Not present. They have been cooked up, framed. They have been procured witness as such. These are the allegations for which they are 510, my lord, of the BNSS. 510, yes. Now, they have been projecting a case wherein they wants to show that they are inconsistent with regard to the evidence, substantive evidence adduced in the court of law of different witnesses. My lord, let us put it in this way. If it is a natural witness, my lord, there will be some differences invariable. If it's a cooked up case, my lord, then the deposition would be, it's like parrot version. It is not here. Apart from that, my lord, we can see that a person in this whole situation wherein the occurrence took place, different person at different places has been there. And even if it's not being, these are present, and so was not present, how can we deduce from evidence on record? It cannot be. Unless the defense has been given a right to cross-examination. If they could have brought in cross-examination that these persons were not there, then we could have left the other eyewitnesses in this case, but they have not done so. What they did is admission during cross-examinations, my lord. One of the witnesses, my lord, here, that he was in a scooter. That is PW. They want to put, yes. PW4, eyewitness, my lord, Shibu Saha. At the time of occurrence in chief, at the time of occurrence, Pinaki was riding a scooter. And thereafter, Achinta so-and-so grabbed hold of Pinaki from behind and then accused people head at the neck and shave up Pinaki with a sharp weapon. Now, he got the ample opportunity, my lord, to cross-examination. Now, he has been subject to cross-examination 19/7/2019. And it has come in the cross. What now? They have clarified it, my lord. On the day I saw the occurrence by myself, Pinaki was sitting on a scooter in front of their gate number 2. In the cross-examination, it has been cleared.
Who's that?
Yes, PW4, my lord. It's been cleared with regard to riding of a motorcycle or sitting, because purpose of cross-examination elicit the truth, and it has come on record. PW4, my lord, in cross-examinations, my lord, on 19/7/2019. His father said, during cross-examination on 19/7, the victim was sitting on a scooty, but I don't know the number of the said scooty. It's been cleared. And these were the previous statement also.
That sitting on the scooter, no one is doubting that.
Yes. So what I am on, they intend to project this particular witness as not trustworthy witness, or that he was not even seen the occurrence, and it's been a procured witness. Now, because of the fact, then in chief, PW4 say, my lord, last line, at the time of a Pinaki was riding a scooter.
No, where does it show that he's riding a scooter?
Yes, PW4, my lord, if your lordship comes to page 15 of the paper book, last line. Examination chief.
Page 15.
Yes. At the time of occurrence, Pinaki was riding a scooter, and thereafter, so and so, so and so, so and so. Am I clear, my lord? And in cross-examination, they have, my lord, clarified with regard to bio-admissions. At page 18, my lord, you will kindly see the cross-examinations part. In between lines, my lord, first, second, third, fourth, fifth, sixth, seventh. Seventh line, my lord, it starts. On that day, I saw the occurrence of myself. Pinaki was sitting on a scooty in front of their gate number 2. And the line, my lord, from down below, 1, 2, 3, 4, 5, 6, 7, 8, 9 line. The victim was sitting on a scooty, but I don't know the number of the said scooty. So these are admissions, man. Yes. So far, with regard to seeing darkness and all, it was puja, light was there. All things has come on evidence on record.
No. What is the okay? You're just arguing over the.
No, my lord, they are taking this case why it is to be disbelieved. This prosecution eyewitnesses why to be disbelieved. So I am arguing that they should be believed because they are consistent with regard to material particulars. They are consistent throughout.
We will see, we will read.
Yes, that is there on evidence.
Over and over again.
Yeah, I'm not reading it, my lord, just pointing out the lines.
Says 5 times already.
My lord,
But it's quite taxing to go over the.
Yes, true, my lord, I understand that, my lord.
Once is enough.
Now, in page 21, PW5, my lord. 21, there is a correction, my lord. Second paragraph cross-examination, it has come. So and so have been grabbing hold of him, and that Biju, it is should be Bipul. That is corrected, my lord. And I will pick your yes. So far, with regard to my lord, that a argument has been advanced by learned counsel with regard to my lord, identification in the doc. Law is very clear. Each and every, my lord, in every witness, it has been followed by letter and spirit. These accused are present in the doc. What is the question that has been put? I am the informant in this case, suppose, and I know the informant and the accused person. So, accused are in the doc. Do you know that? See, I know the accused person. That has come on evidence and record. Now, so far TIP is concerned, my lord. They're trying to confuse this honorable court. TIP is for a person who is unknown to the witnesses and to the informant or the victim family members. A dockety take place at my night.
According to you, all the accused persons were known persons.
Yes, within the vicinity, my lord. Within the vicinity stays. And there is dock identifications, my lord. They are saying there should be another dock identification should be reflected. Nowhere it is reflected, my lord. And TIP is been made, my lord, when witness doesn't know the accused persons. So police during investigation caught hold of them. And thereafter they have been put in jail. Now the learned magistrate goes there, make a TIP chart with the same build, my lord, as per the jail manual, all the accused person, including that two accused persons who has not been, my lord, identified by the witnesses.
How long are you going to?
No, not much, my lord. I have been put in a line. Then the witness see by seeing their eyes, body will recognize from that particular line. So TIP chart records it. Now during evidence, my lord, this TIP chart has been exhibited. It is a corroborative evidence. And then, as because these witnesses were not known to this particular person, although eyewitnesses, but he has been covered his face or otherwise, then the dock identification is necessary. So in that case, TIP will be necessary, supported by the dock identification. And apart from that, ROPP is
But out here,
weapon.
but in this case, there is no question of
Dock identification, because well known everyone, my lord, in the location.
required.
Yes, and the witnesses, independent witness, the person concerned, rear gate and front gate, they have taken a ground, my lord. My lord, rear gate doesn't mean that it's in the backside of the house. There can be two gates. One is being used at is for ingress outgress, and another gate is for the rear gate.
So according to you, rear gate can be the front gate also.
Yes, front gate and the side gate, there can be two.
And front gate can be the rear gate also.
Yes, my lord. But the question is this: how we are projecting the case? Each been on the front gate, some is rear gate, my lord. From that point of view, if there are two gates at the front, one is the front and one is the rear. One rarely use this.
So the front of the zebra can be the backside of the zebra also.
That's a different issue with regard to a material particular which is there. Now, if I use a separate A gate, my lord, the Chief Justice Bangla have two gates. One is been used for entry, one is for exit, my lord. So, my lord, one will become the front gate, one become the rear gate.
No.
But both are in the same line.
Up to that extent.
My lord, whatever it is, but these blood samples were collected, sent to, and that's the place of occurrence. It's not been disputed.
Who's that?
My lord, the deceased blood.
Follow the disease blood group.
My lord, the blood group that an occurrence took place, and it is human blood, and it's been proved, my lord, and it's been collected at the place of occurrence. It's not been disputed. My lord, it can be, it is presumed to be, my lord, the victim blood.
We presume beyond all reasonable doubt.
No, my lord, we'll kindly come to that particular witness, my lord. PM report, my lord, and apart from that particular serologist, my lord, examine it's human blood. Now, my lord, if there is anything, this is subject to cross, they have to bring on record or evidence on record. Fact has to be assumed and presumed from evidence and record. There is nothing. with regard to this.
Facts cannot be presumed.
Fact has to
It
be-
should either be there or not. That's all.
No, the place of occurrence has been proved beyond reasonable doubt by the witnesses' ocular evidence, by scientific examination with regard to human blood has been found at the place of occurrence. That's my case.
Human blood, but
Yes.
whose blood we don't know.
We don't know. It's been part of an investigation. For that proper lapse of the investigating authority, whether eyewitness has to be disbelieved. Absolutely no, my lord. It's been consistent altogether. Here or there, my lord, with regard to that first she came, PW3, seen the occurrence, she may not have seen other persons there. So in the chief, my lord, in the cross, it ought to have been a burden.
Okay, that
And next,
you were going to the weapon.
yes, weapon, my lord. My lord, it's a weapon which has never been seen by any of the witness. Somebody is pointed sharp.
Identified.
Yes, it's not been identified and not been recovered during investigations. For that purpose, whether it is fatal to the prosecution, absolutely no. Because there is nothing on the prosecution witnesses, my lord, which has to be disbelieved. The injury itself in the body, my lord, has been supported by the post-mortem examination. Somebody says chase belly, my lord. The injury is from top to line-wise, 15-inch here, as it appears from the inquest report. So it's from top to bottom. Belly starts from here or here. Doesn't matter. It's a cut injury. A simple, ordinary layman sees an injury to belly.
Well, it's
So-
centimeter, man.
Whatever it is. So far weapon is concerned, it can be caused with regard to this ligature and all such things, and we have discussed this on yesterday itself, my lord. That is not been disputed.
But what is the weapon?
Weapon, my lord, some kind of weapon that has been used, maybe, my lord, like Swiss blade having teeth in this. You slice it that way and slice it that way. These are the two instruments wherein this has been broken, my lord, cut off.
Can it be nail cutter? The nail cutter?
No, it cannot be a nail cutter, my lord, because nail cutter, their grip has to be there, and here nail cutter happens to be here. Grip and cutting is this. It cannot be possible that way. It's difficult. But whatever it is not, evidence on record supports it's been consistent. Some inconsistencies are there, and which make it more natural that it's not been tutored. Immediately after occurrence, these versions were recorded.
Which makes it more plausible.
Absolutely. If it is been parrot-wise, my lord, tutored, it will be a parrot version, 2 lines. PM is not conclusive, my lord. That's been stated with regard to one of the ground that has been my learned senior counsel has argued. PM is not conclusive. Post-mortem report. Yes. My lord, what is the ground of this death? What are the injuries? It's not been written there. Ordinary course of nature, this will be this. But it can be seen, my lord. My learned senior counsel was reading 299 and 300 with regard to culpable homicide amounting to murder. Now there are 2, he is identifying 3. Or is there in between? Anything can be there, my lord. Or. Yeah, 300. He is relying on the 3, not the other 2. Why?
No, I concluded at 3.
Yes.
It's not
I-
that I have deliberately noted.
Cause of death is there, my lord, in the postmortem report. 300, yes. 299 explanation. Oh, 300. Oh. Whoever causes death by doing an act with the intention of causing death. Now, he doesn't have an intention of causing death, and I am submitting with regard to the fellow persons who are co-accused in this case, co-appellant. Now, whoever caused death by doing an act with the intention of causing death, or with the intention of causing such bodily injury as is likely death, or with the knowledge that he is likely death, first injury has been made, second injury, repeated injuries. And they are some in substance with regard to this. 1, 2, 3 belongs to the same family. 4 is separate. And it is premeditation from the factual metrics of this case as come on evidence on record that a threatening has been given to an independent witness. He communicates to this deceased person. It's been on evidence on record. It's been in the previous statement. It is in 164 statement.
I think we should put that on the citation.
My lord?
Basically,
Yes.
your case is beyond that, there's nothing more. I think you've covered.
Yes. So what I am on, my learned senior colleague has been relying on our part and the latter part. I am relying on the other part. Because he knows this, and these are all vital part. This. And these are the persons, they will come on evidence, although they are unarmed. These witnesses all said they are unarmed. So they should be believed. Because they would have, if my lord tutored or otherwise, they would have said this person has put in another person. These are the person who hold it, my lord, and causing 2 injuries. There is nothing on evidence or record. They prevented it. A human nature, my lord, prevents. Don't do it, nothing. So they are in hand in gloves. The intention with regard to causing this murder is been on evidence on record. Because a threatening part has been given to PW4, who is an independent witness man. Here in this case. And how he is inimical or otherwise, nothing brought in cross-examination. Yes, delay in lodging affair. One type of argument has been made the police station through the police station. It depends, man. If my family member is in that particular state, even it is not a murder, it's a heart attack, my lord, or otherwise it's a crime being committed, dokaiti. I may not prefer to go to police station first. I will have to go to safeguard this one, man. Mind this.
What about the 164 statement of PW6?
PW6, my lord. I come to that directly, my lord.
Page 127.
127, yes. Dulal Devnath, my lord. Yes. I saw the victim Pinakide lying on the road near his house and he was bleeding. I picked him in an auto and took him to hospital in Lanka along with Tapas Devnath and 2 other persons I do not know. I met Papu Yadav at Syndicate Lanka and met to Lanka PS in auto. The doctor referred to him home. We took him to home hospital in an ambulance. So from there to ambulance. Along the way,
Lanka PS.
Lanka PS, yes. I met Papu De at Syndicate Lanka and went to Lanka PS. And went to Lanka PS in the auto. I met so-and-so Syndicate Lanka and went to Lanka PS in the auto. So he has gone in, my lord, and thereafter informed this with regard to Lanka PS. But no effort, this is with regard to, my lord, Papu De, my lord. Papu De is evidence, substantive evidence, my lord. PW6, kindly see, my lord. It's been there, my lord. What was his version? It has been there on evidence on record also. PW13, my lord. Consistent. PW13. I am the complainant. I know the accused person. This is Pinaki De was my elder brother. The incident took place 6:30, so and the visa in front of a gate of her. I was at Lanka bus stand at the time. So he was not at the place of occurrence. Then I received a phone call from my house and
You see, 127, page
Yes.
127
yes,
is by this Dulal Devnath.
yes. That is PW, my lord. 6. Yes. I know the informant. The incident took place so and so. Coming there, I found 4 persons going on a run. I saw many people gathered there. He's not an eyewitness. Thereafter he came. I saw many people gathered in the rear village so and so. Later, Topos, Piklu, and I said that Pinaki should be taken to hospital in an auto. Pinaki was taken to Lanka hospital and therefore he was referred to so and so. While I was taken to hospital, Pinaki said that so and so.
So according to you, PW6 is not an eyewitness.
Not an eyewitness. Because he came in, he saw him, he arranged the auto, along with him, other person gone. There is a dying declaration. In the auto, it has been made. And this statement, my lord, is been corroborated, my lord, is been 164 statement also at 127. Same person, my lord. And what he deposed in court and before the police is the same. I met Papu at Syndicate Lanka and went to Lanka PS in the auto. So I met Papu Day at Syndicate Lanka, went to Lanka PS in the before or after?
You read the first paragraph.
First paragraph of CW6. 127, yes. I saw the victim, Pinaki. They lying on the ground near the house. He was bleeding. I picked him up in the order and took him to the hospital at Lanka along with Tapasi Depla and two others. I do not know. Now, reaching the hospital, it has reached. I met Papu Day at Syndicate Lanka and went to Lanka PS. When? After his declared death or otherwise? The doctor referred the victim to home hospital and we took him to home hospital in an ambulance. So it is before or after, it's not been in sequence, my lord. It can be after also. For that person, that reason, my lord, why to be disbelieve this particular witness who took the deceased to the hospital in an auto?
Okay, can we have a citation?
Yes, my lord, I will do the recharge part and get back to you on Monday, man. Definitely. Definitely, my lord.
No, for doing definitely.
Definitely, there.
You are ready for today. Yes, madam, anything to say?
I'll give us a minute.
Yes, ready? What else have you got?
Oh, GD entry I have already argued, my lord, with regard to 2 persons' name is 3 persons' name are not there.
Look, what you can do is you can make a small. bullet
Yes,
point.
I will.
You
I
can
will.
give to your volunteer.
Yes.
Now let us hear the PP.
Yes, yes. Please. There are some I will compile and give it one by one.
With the bullet points and what is the
Yeah.
point to be which is to be supported by the judgment. Yes, madam.
Lordship, I'll not take much time, Lordship.
I hope not.
No, Lordship, because everything Lordship have known, Lordship, or Lordship have heard from both sides, Lordship.
No, I've heard your side.
Lordship, my side only I will rely on the landed senior Lordship regarding eyewitness only, Lord. As my landed senior have already said that PW 11 is most reliable eyewitness.
Not reliable. I said he
I-
was the only
he-
eyewitness
I will-
present.
present, that can be relied.
That can be looked into.
Looked into. Now, it's a correction, Lordship. Looked into, Lordship. Then that is also sufficient, Lordship. For a murder, a single witness is sufficient. Because only his little thing, discrepancy is that he have told about the injury is from chest to belly. And he have not mentioned about the neck, but he have later on said that blood bleeding from his neck also. So, Lordship, I think that will also suffice for convicting Lordship. Because he is reliable, Lordship. Other are there, Lordship. And in case of PW3, Lordship, she is alone. As my landed senior have already told, Lordship, everybody has viewed the occurrence from different place, Lordship. Nobody is from the same place with same group of people. Everybody, one from soap, one from a distance of 25 meters. So what they have seen, Lordship, they have stated, Lordship. As nobody has tutored, making a group and giving a instruction that you say this. So what they have said, they have told to the court, Lordship. And everything is consistent, Lordship, as because the facts remain same, Lordship. That 2 persons were holding, 3 persons catching, and 4th one stabbing. The fact is that, Lordship. Little here and there is there, discrepancy is there, Lordship. But that much only, Lordship. I'll not go because Lordship have 4 times Lordship have gone through.
Evidence.
So, Lordship, regarding eyewitness, I will give 1 Lordship.
Bullet point.
Oh, yeah, Lordship. 1 eyewitness is sufficient for bullet point, Lordship. Only 1.
Judgment
I
issue from the key.
Yes, Lordship. That, Lordship, plea of alibi is taken by one of my learned friend, Lordship. That is
Not one, all 4. Second, but I have.
No, we are not on that, Lordship, because that is not.
That's already
Because
rejected.
that is rejected. There is not such incriminating materials regarding that, Lordship, that they can take plea of alibi, Lordship.
So if it's rejected by the trial court, does the High Court have the power?
No, Lordship have Lordship,
Any Lordship.
absolute power, Lordship. There is no question, Lordship. Lordship, but Lordship will go through the records. Lordship will have to see that whether there is something which similar to get relief from plea of alibi, Lordship. There is nothing, Lordship, we have all have done. Lordship have also done. But still, Lordship, it's up to Lordship.
Your submission is not very long, you're correct.
Lordship, because already Lordship have granted, Lordship knows better, Lordship. Now, so we are just guiding Lordship, by assisting.
Assistant to come to a jurisdiction. My lord, one thing I have been left out with regard to defense witnesses. One online I was seeing, my lord, one senior considerers argue that the lower court below has started from the defense and therefore negated the defense story. And they negated the defense story on the basis of they have the right to edit defense witness, we have the right to cross-examination. Right to cross-examination, the admission been made, and as such it has been rejected. So far, their plea, it appears from the suggestion in the prosecution, minor witnesses, cross-examination is plea of alibi. Nothing else. In 313, I was not present. For their purpose, they examined, they were subject to cross-examination, demolished with regard to this. One said, one kind of argument came in, 2012 incident, MSC case was there. It has been brought on record, by way for cross-examination of the defense witnesses, that there is no certificate with regard to, my lord, partial handicap or otherwise, permanent disability or otherwise. It has been admitted facts. And they are the perpetrator of the crime, and this has been proved by the prosecution, my lord, to the best, my lord, way, my lord. That is my submission. And a trial court can start from the PW1 also, you can start it. My lord, it's an art of writing a judgment. It's a canvas from where I start it to where I end it.
Supreme Court pronouncement is that one has to write the judgment from the prosecution story. Because prosecution has to stand on its own legs. Cannot take the weakness of the defense and start. Of course, that's one aspect. My learned friend has just submitted, my lord, that we have to been forced to be cross-examined. We have not cross-examined or this. My lord, an accused has got every right to keep silence till the judgment is pronounced, my lord. It's not that I have to cross-examine. Because if I can show it from the chief itself, my lord, that no case has been made out against me, why should I cross it? I can decline it. There is no necessity of any forceful cross-examination. It's my right. If I don't avail it, it will harm me. But if the prosecution itself is not able to prove its case by adducing evidence in the chief itself, then why should I take the pain and risks of cross-examination? So there is no necessity that I have to cross-examine to establish my case. Because I have to establish my case by way of at the most preponderance of probability. I don't have to disprove the prosecution case. Prosecution, on the other, has got a heavy duty to prove the case all beyond doubt. There should not be any presumption that he is the perpetrator of crime, he was involved in the crime. So here nobody was caught red-handed at the time of occurrence because all has fled. So the facts remain now that whether in the dark they saw the right person, and that is what I was submitting. I have not submitted regarding TIP. I have submitted only regarding doc identification. Yes, these were the person on that day we saw. He was armed with weapon, and this 3% was catching the accused person. That would have been a substantive piece of evidence. And identification for the first time is for the TIP where the person is unknown. That much so. But otherwise,
They all known to each other.
yes. And knowing is a different thing and identification is a different thing, as I submitted in the morning, my lord. So, my lord, what I, in the larger frame of my argument will be this, that the prosecution has suppressed the genesis of the true facts. Prosecution has suppressed the fact from coming to the court, my lord. Because it was in another note, they have built it in another note, my lord. That is my respectful submission, that there was suppression of fact. The true fact has not withhold, my lord. And I have not to bring it. It is for them to bring it, and the prosecution has to stand on their own legs. An accused can never be forced to cross-examine it. My lord, lastly, one legal judgment. I'll give all, my lord, but right now, only two judgments which I'd like to point out, my lord. Well, I'm just reading from Subram case, that is, my lord, 1993 3 SCC 32, my lord. Para 11. So whether
1993,
my lord.
PSCC.
3 SCC, page 33. 32, sorry. Para 11 is the para which I will be relying. Just in this case, my lord, our case accused has been convicted under 302 simpliciter. No 34 has been invoked. So in this case also same thing, but only it was 149. And as we know, there are three aiding section, helping section to convict the others. That is 149, 34 and 120B. But 120B is also a substantive offense because punishment is prescribed. 34 and 149, no punishment has been prescribed. Only to aid the court to see that they were a part of the game plan of the crime, so they can be held up for 34 and 149. 149 needs no prior meeting of mind. 34 needs prior meeting of mind. So here the prior meeting of mind has not been brought in because there was no enmity. So nobody will go and kill anybody. So that is also that aspect, my lord. Because common intention is earlier. They have met and they have put their mind together. And then after they have come out. But in 149, you did not have to play only your standing, like in a mob lynching case. If you are present and one of the, not a bystander and one of the participant also is good enough. So this is the way difference between what 34 and 149. 120B, of course, 2% meeting together and planning something like that. So 120B is substantive offense, though it's a one-way helping offense, and the other way is also a substantive. But 34 and 149 is not a substantive offense. So in this case, the charges were under 149, 302. Similarly, in our case, like simpliciter, then what the Supreme Court said, my lord, I'll just read it. Since appellant 1 Subram has not been charged for the substantive offense of murder under 302, even the trial court which tried the 6 accused person was not justified in recording a conviction of accused against him for the substantive offense of murder punishable under section 302 IPC. And after framing a charge against him for the offense under 302, read it at 149 IPC only. A person charged for an offense under 302 IPC read with section 149 cannot be convicted of the substantive offense under 302 IPC without a specific charge having been framed against him as envisaged law. So in order to convict a person under 302 simpliciter, the Honorable Supreme Court has said there must be a separate charge only under 302. There is no charge under 302. 302 read with 34 is the charge. Conviction for the substantive offense in such a case is unjustified because an accused might be misled by these defense and in his absence of the charge for the substantive offense under 302. Appellant Subram was never called upon to meet the charge under section 302 simpliciter. In our case also, I have not been asked to answer the charge of 302 simpliciter. Monipal to say main palne ki 210. So this is a long para, my lord. I have just pointed it out. I will quote it in it. Now, my lord, one more judgment. Just reading it for today, my lord. I'll compile it and give it, my lord. So here the charges as I have read it in the morning, my lord. I must know what. Yes, 210. 2010 SC 3292. Para 9, 12 and 13. I've read it in the morning, my lord. So here it is has been crystallized, my lord, that the charges shall contain particular as to the person against whom the offense has been committed. Otherwise, the accused was thus clearly misled the error of charge which caused prejudice to the accused, thereby occasioning failure of justice. Therefore, we are of the view that there should be a new trial after charging him with the offense of outraging the modesty of Sheila Devi. So the charge is, my lord, different and the conviction is in a different law. I have been convicted under 302 simpliciter and there is no charge against me under 302 simpliciter as this 93 judgment say. So in order to convict me under 302 simpliciter, there must be a charge under 302 only. But charge is under 302, 34. Yes, absolutely. That is one way to say one. So in absence of that, I cannot be convicted only under 302. So this much
So you're giving us the.
Yes, written. By Monday, I'll give
You
it.
can give it to the chamber.
Sure, man.
Yes.
What,
No more argument.
well, we can give it in the also in the
You can give it.
Bench
You
is
can give it to bench.
Bench is
Yeah.
that will
You
be.
don't have to do. Huh? Huh?
equal to. Yeah, yeah.
So we'll keep it as,
Mail in the court
Mail.
mail. Oh, no, দুইটা দিয়ে দিন, mail ও তো দিয়ে দিন,
Two sets, my lord,
with the list of judges.
with the list of them.
My lord, now coming to the vital part, my lord, that IA part, my lord. Just, my lord, give me 5 minutes. There is an IA, my lord, which your lordship has explained it twice, my lord, cancer patient, my lord. My lord, just bear with me for 5 minutes. I'll just make a submission, and this will be probably the last submission required also in the whole case. Now the baby girl, my lord, the angel, my lord, she has become a bit grown up, my lord, and she has been suffering from blood leukemia and under the care of the guardian because the wife in the of the accused appellant is 45 permanently disabled. Because of that ground also bail was given. Now, my lord, in the meantime, after the Supreme Court exercise, my lord, he was allowed to go on bail, my lord. Subsequently, when she was taken to the B. Bora Cancer Institute where she is ongoing treatment, if your lordship will kindly take my pages, my lord, I all of Devoniki. There is an additional affidavit after. Yes, there is an IA filed on 21/7/25. So while the IA was pending after the Supreme Court direction of 6 months, my lord, then, my lord, she was taken to the hospital as a regular checkup, my lord, and she was brought before the B. Bora Cancer Institute, my lord, and accordingly, she was examined, my lord, on 18/7/25, my lord. Page 24, running page, Annexure 3, my lord. Additional affidavit I have brought in the subsequent development, my lord.
yes.
So, my lord, when she was taken to the hospital, my lord, many a test was suggested, my lord. At that time, it was remaining inconclusive. Then she was referred to the gastro also. Then the main part comes from Annexure 4, page 26. Then where she is also undergoing treatment with a super specialist at Calcutta, my lord. This is HG Eco Cancer Center. This is to inform you that patient period day and UD number such is known case of BAL or BAL cancer. That is acute cancer, minor would like to come for evaluation and treatment at our HG Eco Center, Calcutta. We are scheduled his appointment for consultation with a consultant, Dr. Joydeep Chakraborty, on 18th August, 18 August 2015 at 12:30. So an appointment is fixed, and for that I have already booked my railway ticket, my lord. So give me a chance that I have the.
No issue.
Hmm?
No issue, no objection.
And thereafter I will come and surrender,
And he
because
should-
in the meantime judgment
18
will
is the
come.
treatment, my lord, 21st, let him surrender by 25th, that's all. Let it be.
Let's fix, so 18, no?
Yes. 18 is
After
the
10 days,
treatment.
2 weeks, my lord, I'll come and surrender, my lord.
My lord, no issues.
Huh?
No,
Nice.
objection for.
Yeah, this probably will be the last, then of course things will change. Even the 28 movie.
ठीक है, of course, no issues. अच्छा तो करने no issues, but.
Of course, of course. So nice of you. So, calendar,
You to object.
My lord.
They have got nothing to say. They have got nothing to say in this. No, he's got no nothing. He's got no standing in this.
No, actually, she is also right, because he is objecting all the time there from the beginning.
Actually,
Informant have a right, my lord.
only to assist.
Yes.
My lord.
It is not a POXO case or anything like that.
No, my lord, so far a high court proceeding is concerned, in appeal, my lord, informant have a right to be heard.
I don't know.
If POXO case, there has to be a notice mandatory.
No, I don't know about have to be heard.
Yes, my lord, that's been judgments, my lord.
That is
He
it.
cannot conduct the trial. In Sessions tribal case, he have to assist the PP.
Anyway, this thing, though, I don't think the PP has any objection.
No, yes,
Child of having leukemia. Is severe.
yeah.
Then we'll fix. Okay, how much time do you want?
My lord, 10 days, 2 weeks at the most, my lord. Because all booked, my lord.
Okay. This is basically she's had treatment.
Yes, my lord.
Now she has to go for evaluation.
Evaluation. Actually, absolutely. She's now becoming okay, as I'm told, my lord. Wife, that is mother of the girl, is also 45% handicap. She cannot move, my lord.
Oh. Yes, right. Right. Mr. The cover.
29 fine.
Assistant Prime Minister.
SJ Chaudhary.
S.Z. Chaudhary. For the appellant number. Right. Mr. What's the council today? 2 and 3?
Oh, but they were there, man. He is for,
The one who was agreed.
yes.
And Vishwas, my.
Ahmed.
For Azad Ahmed.
Ajad.
Ahmed.
Azad Chaudhary.
Then
Ahmed.
the appellant number 2.
Azad Ahmed.
And Mr. M. Biswas for respondent number 4.
She is from business.
No, he was there. If we don't put his name, he'll get angry. No. There. Also had Miss A. Begum, additional PP. And Mr.
AK Bhuya.
A.K. Bhuya for the informant. Informant, tax respondent number 2.
Yes, responded.
Hearing concluded, judgment reserved. So, then if we just, so we have to time our judgment after the, sorry. No. Take some time in here, because they're going to bring it cannot be disposed of. Right, hearing concluded, judgment reserved. No, there is, I hear you, right? Where is the Supreme Court order? Let me see.
That I have annexed it, my lord, in the main IA, my lord.
Okay, I've got it. Clear. In the IA, right?
IA.
Same thing, huh? Same.
Yes, page 8, my lord.
Then you right? This is an, this is an application for extending the period of the interim bail granted to the applicant by the Honorable Supreme Court till the main appeal is decided. The main appeal has been, now the counsel for the parties have been heard and the case has been reserved for judgment. However, prior to however, the counsel for the parties have taken time. Have taken 3 days time, 4 days time to file the list of cases in support of their submission with regard to the main appeal. Accordingly, the main appeal has been reserved for judgment. And in the meantime, the applicant's child who is suffering from leukemia needs to go for further evaluation in the cancer center at Kolkata. wherein her appointment has been fixed for 18th August 2025. Keeping in view the above, that we extend the bail granted to the appellant. For today, 30?
40.
It said, for a further period of
2 weeks, man.
2 weeks.
Good enough. On 29, I'll surrender.
This is the matter on
29, yes. 28 or 29.
Where is the matter?
2 weeks will be 28, my lord, so 29.
Where is the matter on 20? For you to get. This is the matter on 1/9.
1.
Hopefully on that day we can pass the order.
29 minor, he has to surrender, that is to be reflected.
Okay, yes, okay. The applicant should surrender before the authorities. Concerned authorities.
No, your lordship will put it earlier, it was put jail authority because otherwise they
jail
will not accept it.
Jail authority.
Yes.
On 29/8.
Yes, I'll surrender and 1, I'll confirm it.
29. Okay. So we dispose of the
Yes,
dispose
can
of
be disposed.
the is accordingly disposed of.
Right.
Then we'll try to dispose of the main appeal on.
In the meantime.
The synopsis which I have submitted, that may be taken as written argument also, that are.
No, not written out. We'll.
That may be considered also.
We have to consider that is your only submission.
He says that.
Yeah, yours.
My way for
Yes,
appeal
yes,
number 2 and 3, I have
yes.
given in the morning hour.
Whatever you have given, that we will consider.
Lots.
We won't say written arguments. But we'll consider.
Lots.
And we'll give it on Monday, my lord, through mail.
Yes. Through mail?
Your lordship has got a mail, man.
Okay, okay. Yes,
Court mail, man.
yes. And you also.
Yes.
PP also.
PP also.
Otherwise,